Good morning, y'all. I almost forgot to put my mic in front of my face. Oops. So, good morning. Welcome in. How are y'all doing? Salty, welcome in. How are you? You were here early. Are you still here? Thanks for coming in. Good morning, Tricia. Good morning, Sparky Pilot. Y'all, my dogs are doing their usual morning thing. Let me shut the door. Hold on. It's playtime in the house. Okay. I have dogs who are in good moods most of the time. How y'all doing this morning? We are here for the Alex Murdaugh pretrial hearing. Lots going on in that hearing. It hadn't got underway yet as of a few minutes ago. They are behind schedule, I assume. So we're going to get into that today, and I'll be back tonight with another show because there's a lot of things that have stacked up this week that I need to get out. So we're going to do that tonight. This will be a standalone show. And I did create a playlist for it because I did watch Alex Murdaugh's other trial, but I wasn't streaming at the time. So we'll follow all of this closely. So I did create a playlist. We can throw any hearings that come up or any updates we do on the case will be in that playlist. So we will get going with that. I'm going to take a look at the court stream to see if they've started yet. And I'll give you guys a little rundown of what we're doing here today, what they're doing here today, or will attempt to do. Oh, haha. How did y'all do last night? Did y'all get some sleep? I did. I was going to go live last night, but a couple things I had to get finished up. So I did that, and then I went to bed, and I slept pretty good. I got to pull up my chat, too. I can't see you guys yet. Hold on one second. I feel like I'm... Okay, it looks like they got started. Let me check the sound on this Court TV's feed, guys. One second. It's kind of low. Let me check another feed. Hold on. Okay, yeah. Way better at law and crime. So we're going to stick to our law and crime. That's what they do for a living. So we're going to stick with them. All right, let me get it to where they begin. They was just standing around having a meetup this morning in that courtroom. I was watching some of it, you're right. I was sitting outside with my coffee. I was like, man, they're just like, hey, how are you since the last trial? Okay. All right. Got it where the judge just walked in. All right, let me take a look here. Uh-oh, my volume's up. Okay. Phew. All right. Welcome in, everybody. My other mods may be along shortly. For anybody just joining, we're going to cover the Alex Murdaugh pretrial hearing. If you catch us on replay later, we appreciate that as well. All right, let me pull up a little bit of information here, guys, and tell you what's going to happen. So they're going to be doing oral arguments for dozens of pretrial motions, right? Some of those will be including a motion to dismiss charges, which don't think that's going to happen. The defense is fighting to toss out all of 4 of the criminal indictments, 2 on the murder and 2 on a weapons charge, claiming the state investigators provided false testimony to the grand jury. Also to be heard is a motion to change the venue. Defense wants the trial moved from Colleton County over to Charleston County. Like, bring it over Charleston way. Okay. While the state has countered with alternative counties. Now, that's huge because later on when we come back and I'll talk about Mickey Steins, how many counties away do we got to go, right? How many counties away do we got to go? Mm. So then also they're going to discuss the motion for DNA testing. The defense is requesting advanced forensic genetic genealogy testing on DNA found under Maggie Murdaugh's fingernails. Hell tested at this point, right? Motion to use prior testimony. The prosecution wants permission to use Murdaugh's own self incriminating testimony from his 2023 trial against him. Hell, if he said it, use it. Motion on the financial crimes. The state is fighting to reuse evidence of Murdaugh's extensive financial crimes to help establish motive. I think they should probably be allowed to do that. People love to have the motive, right? We got to have a motive. Without a motive, we didn't really have a crime. That's kind of like saying, do you got a plan for self deletion? Because otherwise, you're not really going to do it. Like, what? All right, I'm in a mood, y'all. I'm feeling a little squirrely. I'm a little upset, y'all. I'm trying to get over it. The house behind me is being sold. Oh, it got sold, right? And it needs some remodeling in TLC, which I can appreciate because I love that little farmhouse. I don't want it to go away. But my friend lives in that yard, and it's this giant tree that I freaking love, and all my birds live in it. I said, all my birds live in that tree, and we are friends, and they're going to be gone because their home is leaving. They came and trimmed it up yesterday. I was like, oh, please, is that where we're going to stop? But I already knew it had to go because it's going to do a lot of damage if a storm comes through. So I'm feeling a little sad today. I'm like, this morning, I'm like, am I a tree hugger today? Because I just want to go over and tell it I'll miss it so bad. It's going to change everything in my world, y'all. My view, my birds. It's okay. I'll get over it. I'll get over it. It's just sad. And I don't know why it's affecting me so bad. Because I love to sit outside, I think, and I've just really grown to appreciate that one damn tree. Anyway, enough of that. Y'all hold space for me. All right. I also want to bring in a supplemental Brady motion. Oh, the Brady Giglio. The defense is demanding full disclosure of any favorable evidence the state gathered since the original trial. They want that exculpatory information. We want that possible exculpatory. Phone data. Dual motion by the state seeking a review and compelling the defense to hand over digital evidence from Murdaugh's phone. Are they going to try to figure out if it was in pocket state? Okay, so that's what we're doing, y'all. That's what we're doing. Hey, CH. They're going to cut the whole thing, CH. It's so close to that old house. The roots, I know, have to go way under that house. And if we get a storm this year, because I'm not out of hurricane season until November, if a big one comes through, that tree's going to probably go and either take out that house and pretty much damage my entire fence and maybe reach my house because it's so big. Anyway, they know that it's got to go. It's sad. It's sad because I'm surrounded by open fields, and that's literally the only giant tree. Well, there's one more behind me, but no, it's fine. It's not going nowhere because it's on a vacant piece of property. But this tree, it's home to so many animals. My little woodpeckers live in it. They come every year. Y'all, I may have to cry later when they're cutting it down. I'll hold space for it and say a few words. Yeah, well, in hurricane season, these old trees take beatings over the years, you know what I mean? So, it could take, well, all it's got to do is have one good storm and it's going to go. Take out that whole entire house. Safety first, but damn, I hate it for all those little birds. I mean, they got plenty of other woods to go find a tree in. We got the woods right back there, but that's the only one right here, right? Like, I understand I'm surrounded by a state forest, but this one's close to my house, and I don't want to see it gone. It's giant. It's so old. Okay, let's turn this on, and I will stop my ramblings this morning. I know, Forrest, it don't. It's one tree. And it's just all them birds go back to it every single year. What are they gonna do? Are they gonna be like, "Oh God, my house. Where do I go now? Got a homeless. I'm homeless. Gotta go find a new tree and fight the other birds because they done laid claim to that tree." See, now I'm worried about the damn birds. Okay, I'll get a fresh coffee and we'll start this hearing. Thank y'all for understanding about my concern for the tree. I love my tribe. Thank y'all for allowing me my space. I appreciate it.
Absolutely.
Okay, is that a South Carolina? Are we in South Carolina today? What's up with the judge and her flanked people? What's happening? That didn't happen in the other trial. Now I got questions. It's n This is gonna be a weird day for me. I'm gonna be full of questions today. It's okay. I'm just asking questions like Karen McDonough. She's a journalist, y'all, so she says it's okay to ask questions.
Okay, good. Let me tell everybody else good morning. Welcome to Lexington County.
Oh, hell. Good morning, everybody. Welcome to Lexington County. What in the world's about to happen here? And I don't mean to be making fun. I'm from the country.
Into the Lexington County Courthouse.
Damn.
As soon as we get Mr. Murdoch brought out, we'll get started.
Okay.
Mr. Waters, how are you?
Fuck, it's damn. Well, hell, bring out the coffee cake and the coffee, y'all. How are you this morning, Mr. Waters? I'm good. I played me a guitar last night. Y'all welcome to my world.
Good.
It's a panel forest.
While we're waiting, let me introduce y'all to my new law clerk. This is my old law clerk. This is his last day.
Oh, it's my old law clerk's last day. This is my new law clerk. Oh, okay. Thank you for introducing us. Let's find out who they are. Let's learn more about them.
So you will not be emailing him anymore. This
Oh,
is Mary L. McKissick, and she will be the new law clerk. And
she's like, yes, I will get all your weird emails now. That guy's like, hey, I'm passing the buck. I'm out of here. Damn. I'm in a mood, y'all, to be silly today. Let's just be silly and pretend all is right in the world.
will be the new law clerk that y'all will be getting emails from. So, just wanted to introduce her so y'all would know when you did get them.
John, while we're waiting for Mr. Murdoch, could I address one administrative thing? I've already talked to the clerk from Carlton County. When you file an order,
Okay, they need to understand some of us are hearing impaired, and my headset sucks. Should I buy a new one? Maybe it's just a me problem, right? Can y'all hear it okay? My headset does suck when it comes to hearing the things. I have to take it off half the time and turn on the computer or my phone.
on some occasions, you copy us when you file it. On some occasions, we don't get it. The order allowing him to be present without shackles. We read about it in Fitz News. We were aware there was an order. If you could,
Okay, thanks, CH.
but when you send an order to Carlton County, if you copy the lawyers,
Hey, we could email that new law clerk and say a bit of advice, right? A bit of advice for those trying to watch your pretrial hearings. Mic the fuck up.
I think you've done that on every order that
tell you, my office usually sends an order.
Oh,
Um,
there he is.
I do that not only in this case, but any lawyer who appears in front of me. I send a copy of my own.
Alex is like, freedom, freedom. They took my shackles off today. Let me wear a suit and tie. Good Lord. Like that's going to help. These defendants really think that putting me in a suit and tie and taking off my shackles makes all the difference in the world. We wouldn't want nobody to be prejudiced because I'm sitting here in orange and shackles. I don't have a problem with them coming into the courtroom with their regular clothes on. I don't. It don't affect me either way. I don't care if you're sitting there in orange, black, red, pink, or purple. You're a defendant. What you're wearing really shouldn't affect me today. But American jurors are like, no, we need to see him in regular clothes. Otherwise, we can't be fair. Like, do the clothes matter? That's kind of like making the eyebrows the point instead of her fucked up behavior. But okay, let's go, America. Let's rock and fucking roll.
Order. I apologize for that.
To apologize for, but once things crank up, getting it quick, getting it next day didn't bother us in this, but it may be that as you make evidentiary rules, whatever, it just, if you.
Absolutely. Well,
Right.
I'll make sure that everybody gets a copy. Again, I apologize for that.
Nothing to apologize.
I usually do send it myself.
Thank you, Your Honor.
The niceties. Y'all reckon they all get together at the what do you call it? Not the club. What's that little fancy place they all go to? I can't even remember the name of it. What do you call them? The country club. They'll be at the country club later throwing back a whiskey over some seafood supper or something. Caught in the low country.
Mr. Murdoch.
Okay, you ready to get started then?
Please ready, Your Honor.
All right, well, let me just kind of do a little housekeeping here. Mr. Harpoolian, let me just address.
Oh God, we got to hear the adults call this attorney Poot until the end of the trial. Y'all won't ever hear me call that man Poot. I feel like I'm not a kid in elementary school. It's not that funny. It was cute day 1, trial 1.0. I don't call the man Poot. I'm sorry. I think that's a little ridiculous.
Kind of what we did last time, as far as making arrangements out at the Bureau of Prisons for a conference room where you could take discovery to your client.
Okay, hey, Aussie Cheryl, it's not just law and crime. I tried court TV first, and they suck. It is what it is. I have no fancy boost the volume for you guys. I got it up as loud as it'll go. I got everything turned all the way up. You may have to just turn your phone up. My phone is extremely loud compared to my computer and my headset. So when I can't hear something, I just turn it on my phone and kick the volume up, and I'm good to go. But I get it. But there's nothing I can do about it, y'all. I am so sorry. I'm struggling too with my headset on because I'm being ridiculous and not using a different alternative method. But it's okay. I'll struggle.
Have you had any issues with that?
Let me just confirm.
None at all.
We have no issues whatsoever. Everyone's been wonderful.
Okay, good. And then I told you that I would check on if there's any kind of download that you could do to the tablet that he has, and there's not. So
I sit on my speaker. I'm messing with you. All right, y'all can hear it. All right, thanks for the feedback. Yeah, it's just this is the court feed. They don't have their shit together as usual, right? And every time I cover a hearing or a trial, I'm not going to sit here and apologize relentlessly for the court's bullshit.
we're going to have to stick with the computer from either the law clerk or one of your staff members going out to the BOP.
We are, at this juncture, we have a law clerk,
CH, you need to email me stuff because I love your feedback and advice. And if you want to email me something, I will be glad to hear it. saltysleuth@gmail.com. Please send me information because I will try to do better. I just don't know what to do. And I don't know people use that sound boost stuff. Like, come on, what? What? So yeah, hit me up. Oh, see, Cheryl, you're good. You're good. It's just, yeah, it's me hogging the speakers. That's all. I plugged them up. No, it's just their bad audio shit as usual. And it's not even Long Crime's fault. It's the courtrooms, the way they're set up, the way and all the courtrooms are different. Y'all, if you're trial watchers, you know that, right? It's crazy we have to put up with it on our ends.
Man back here, who's going down there, and of course, 2.5 hour drive, typically it's 2.5, 3 hours with him, and then 2.5 hour drive back. We understand. We're willing to put up with that.
Okay, Aussie Cheryl. Another creator mentioned something about, I'm not going to sit here and yell at y'all. Let me ask y'all a question. Is my mic too loud? Because I can turn it down. I don't mean to yell at people. I talk loud. I was trained to talk loud my entire life because my daddy can't hear me. So if I appear to be yelling at people, I apologize. If y'all just let me know, hey, your volume is too loud, I'll take the feedback and turn the mic down. Because I don't ever want to be seen as a screaming, ranting lady on the internet. So if I ever get too loud, y'all can let me know. I don't become offended easily. I don't. And I know I get loud, but I'm not the only one on the internet that gets loud. Then not by any means.
Okay.
That's not a problem. However, we have retained some experts, and at some point we're going to need to, and they've done this in the past for us, but we've done some FaceTime meetings with them so they can show Mr. Murdaugh
I'm with you.
drawings and all those sorts of things. So we're going to try to, and I don't think they're going to have a problem with that, but
Okay, now I see CH. They're just rambling in the courtroom. I'm trying to read y'all's. Okay, WIS News 10. I like them. Hold on. They got a louder feed? Perfect. I'll try that. I haven't had my grits this morning yet. I'm going to do that after this show. I got my plan. It's a perfectly laid plan, Aussie Cheryl. They might try to change it. Who we got? Let me go try to find this feed that CH recommended, guys. Hold on one second. We don't want to be the Hot Mess Express on purpose. It's accidental when it happens over here. And we just roll with it. Jess yells when Jolene streams. She can get all the way over it. Kind of like Jennifer Coffin Dapper. Stay in your lane and go sit this one out. Like, for real. I don't like that lady. Never did. Don't know much about her. Never watched a damn thing she ever did. Like, does she even matter? Like, who is this lady? And then all this bullshit comes out about her. I'm like, I knew I was right to avoid that one. Jesus Christ. Oh, that is louder, CH. Oh, hell yeah. Thank you, CH. Okay. This is much better. Thank you so much, CH. All right, now none of us should have to struggle, especially me in this crappy headset. I bought a better one time and then the mic wouldn't work. I could hear perfectly, right? But the mic just would not configure and work. So I broke out the cheap one. I got it back out, and that's what I'm still running with. But, okay. You don't even know what grits is. It's not a cereal. Golly, how do y'all describe grits to somebody who don't know what grits are? Well, shit. Help me out, somebody. Explain to her what grits are. It ain't porridge, and it ain't that crazy ass oatmeal. I do not like the oatmeal. All right, I tried to go back as like rewind this, so we're just gonna start it right where they start, guys. All right, I'm gonna mute out, have some coffee, and now we can listen without the struggle. Thank you, CH.
Today, because I plan to hear all of your motions except for 3. And I've kind of picked out the ones that I thought we could kind of go through right easily this morning. I know that both of you renewed your discovery motions and your reciprocal discovery motions. Let me ask the state, right now, do we have any problems with discovery?
Not that I'm aware of, Your Honor. Obviously, we have filed a motion as it relates to that defense phone extraction. That's obviously one of the things on the table today.
And I'm going to rule on that today.
We are obviously always auditing discovery, and of course, it has been a few years since the trial, so there may have been things that we would turn over that have developed since that time, and we're in the process of doing that, but we are not aware of any discovery issues at this time. Indeed, not too long ago, the defense realized that one of the original big murder downloads that we gave them back in August of 2022 had been corrupted on their end, and our staff worked and did hours and hours of work to re-upload all of that, to provide that to them. So my understanding is that they have all that, which they had then at the time. But they have
Yeah, it's certainly not anything new,
Not
just
anything new.
something you had to recopy
That's
and
correct.
give to them. Okay. How about you, Mr. Hartsulian? Do you have any discovery issues right now?
Mr. Griffin would like to address that, Your Honor.
Mr. Griffin, be happy to hear from you.
Yeah, I'll come up here, Your Honor, since I'm on the
Yeah.
microphone. Good morning.
Good morning.
I want to make a record. I mean, there's ongoing obligation by the state. They say that
There's an ongoing
they
obligation by both of y'all.
and so there's some items that we would have expected to receive by now, and we have not.
Let me know what those are. What are they?
So, as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in United States Supreme Court, Giglio v. United States, and these include plea deals and promises, even secret agreements, evidence of witness bias, and credibility issues of police where there's evidence of past
Secret agreements? What you talking about, sir?
misconduct. And in that category, I have a few items as to secret agreements. There's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021,
Oh, cousin Eddie.
almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it. With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award.
Oh.
Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owens, SLED agent, I think he's retired now, in his HR file, was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter? There's another SLED agent who was the lead SLED agent in the financial crimes case. Well, right now, we assume he's going to be a witness. He retired from or resigned from SLED. We don't know exactly under what circumstances, but then he went to work for the Charleston County Sheriff's Department. On June 8, 2026, Captain Ryan Kelly was terminated from his position, according to the Sheriff's Department, for conduct unbecoming, harassment, improper procedures. And so that would be information. We don't have subpoena power unless we subpoena them to a hearing. They have control and can request this. We don't have it, and we would like it. And so, Your Honor, that's some Giglio material, some Brady material that we have, think we're entitled to. And as you know, Your Honor, Brady is evidence that is, could be exculpatory. We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that murder weapons were connected to the Allendale County murder.
What?
Now, how could that be? And so we would like to know, were Murdoch murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdoch. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdoch murders, either their test is bad or someone's out there using the gun to murder other people.
That's huge. I take your feels out of the equation right now. Ballistic testing's already in question in other cases. So when they upload the bullet from another crime, it'll go into that computer system, and it's kicking back results that match what happened in the Murdoch case? Really? That's odd. I need to know more.
And so we would like that information. And then there's generally, we are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alec Murdoch participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligation seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but we don't have the benefit, and we don't have the ability to contact law enforcement and get this information. So those are our concerns.
Okay. Mr. Waters, let me hear from you on the Giglio
Yes, ma'am. First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, they, of course, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation very well.
Right.
As to
And those cases are still pending.
that's correct. Yes, sir. Yes,
Okay.
ma'am, Your Honor. As to Colucci and Kelly, we are all aware of our Giglio obligations. And as far as the Colucci matter, the judge, as I understand it, I wasn't involved in that matter, but ultimately dismissed that indictment just without prejudice, just to allow some additional information to be presented back to the grand jury that the individual said that he forgot. But there was no finding that he misrepresented anything. I have made inquiry, and I am not aware in any HR file of a finding of dishonesty or anything like that that would ultimately trigger Giglio. I have made those inquiries and I will renew those inquiries, and if anything is applicable there, I will immediately provide that to the defense, as we do every law enforcement witness in the case. The same thing with the termination of Ryan Kelly from Charleston. My understanding
That was
is
SLED agent.
he was a SLED agent. He went to Charleston County Sheriff's Office. And, deputies served at will, and he was terminated. But the inquiries I've made, and my understanding is that none of that had anything to do with dishonesty or falsification of reports or anything that would go to Giglio, that they were personnel matters. I will, of course, re-verify that, and if there's anything that needs to be provided in that regard, I will, of course, provide that to the defense. But that is my understanding at this time. And again, we always renew our Giglio inquiries for any law enforcement witness that testifies as we move to trial. And obviously, if anything's forthcoming, we'll provide that. But those issues are not there. As to tips, we provided a lot of that information before. But as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your
the
Honor.
murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody
She's like, tell me about this murder weapon. What? She's like shaking her head. We would all like to know more about that. Let's let him talk. He knows nothing about it. But the news people do. We got some investigating to do, y'all. We got to find this news report.
told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay.
Yeah, that they weren't advised. Like, I need to know more about this news report and where that came from. Why wouldn't they notify it's just, that's weird. The whole thing is weird. We got to look more into it. They did remove Lori Vallow's death penalty because of prosecutorial misconduct. They never turned over some discovery to the defense, right? On time, even after being warned. They don't just snatch the DP away on the first thing, right? They were warned. So Idaho blew it. Idaho didn't really want to fight the DP anyway. That's why we are so messed up with this Brian Koberger situation. But yeah, and Ann Taylor, Koberger's attorney, kept bringing that up. Lori Vallow, in her court documents and in the hearings, wanting to remind everybody how Lori got it removed because of prosecutorial misconduct. We don't need that stuff no more than we need defense misconduct, right? We could be your defense attorney today or your prosecutor. How are we going to roll? Yeah, we don't need all that mess because we get new trials. And guess who's trying to get a new trial? Lori Vallow.
I, I hope that answers your questions. He's gonna get back with you. He's gonna double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's gonna get back with you. As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of, and we can go through a long litany of that. But there was a podcast. There's a reference to what I just said to you.
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
But we would ask that they look into that.
And I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. 'Cause I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery here today.
Okay.
But, and Your Honor, we would ask for the underlying documents on the Colucci matter involving judge's ruling, anything that was filed, anything related to the Colucci matter, and we'd
On
ask
the one that's going back to the grand jury that was dismissed, that was referred back or dismissed without prejudice.
Without prejudice, just to represent to the grand jury is my understanding. And again, my knowledge of that case is very limited. All of this really was publicly reported, and there's a public transcript in the judge's ruling, which is available to the defense.
Get it from the clerk's office.
Yeah.
Well, we do have some materials, but we don't know if we have all the materials. And then, Agent Kelly's, documentation relating to his termination. I don't think it's just sufficient for him to say, well, I've asked and there's nothing related to misconduct, because what's publicly reported seems to be related to misconduct.
Well, there's a difference between what's in a personnel file that may be.
That's
fireable
exactly right. And
offenses.
there's a different
Exactly.
avenue to go. When you're talking about law enforcement's personnel file, usually you can ask for them, but then they come to me. And then I go through them. And in camera. And if there's anything in there that I think that needs to be reported to both sides, not just one, but both, then I'll give it to you.
Absolutely, Your Honor.
We'd love for that to happen here.
I don't mind doing that.
All right, thank you.
That's
Absolutely.
fine. You just, y'all need to get together, get them. I don't want anybody looking at them. I want them delivered to my office.
Thank you, Your Honor.
We'll get
Okay.
that done, Your Honor. Thank you.
All right, next, Mr. Harpootlian. I think this motion should be moot. I heard Judge Gergel dismissed without prejudice, and I think you have it on appeal, to modify the protective order for your federal case. Are you going to withdraw this and maybe refile it later after the appeal?
Yes, Your Honor.
That's what,
We filed it before Judge Gergel precipitously dismissed the case.
perfect. I figured that made this motion moot, and I could get rid of it. If you need to refile it, please feel free to do so after the
Once the Fourth
appellate.
Circuit sends it back, we'll be doing that.
Okay. Then my next motion was the state sent me a proposed order for an amended protective order. This is by consent because I received your email, Mr. Harpootlian, that you consent. Mr. Waters, what I want to make sure is because, this is a new case. That means there's new filings. And in your motion for this proposed protective order, you listed a bunch of stuff. Is that included in all of this, or was that just a history exhibit B that you gave me?
Yes, the Exhibit B just was for, this is a new case, but I just wanted to provide the court the sort of the historical development of the protective orders and sealing orders in this case. So
Why we're signing it, why I'm signing it, and y'all are agreeing to it. Is that
yes,
right?
ma'am. It was just for the court's information as to how things started, how they progressed through the first trial, and how they now set up for Your Honor.
Okay, well, if you both agree, I'm gonna tell you, I'm going to sign it. I also took the liberty of putting a consent for both of you to sign. If y'all sign that, I'll have the clerk file it and take it back, to Colleton today.
Want us to do it right now, Your Honor? Maybe we approach.
And I'm gonna give it to the clerk, and that one's done. Yeah. Thank you.
Thank you, Your Honor.
All right, now, the next motion that I wanted to hear, Mr. Harpooling, I did not get a response from you, but this is for the voir dire. It's a questionnaire,
Your Honor, we agree there should be a questionnaire.
okay?
But we think as this case develops, there's going to be additional questions we're going to want to have in that questionnaire. Now, what we did in Colleton, not that that matters too much, but what we did in Colleton was we had this questionnaire they filled out and mailed back in. And then when they got there was an additional, more case-specific questionnaire. We're not going to be mailing questionnaires to jurors until
January.
January, so we've got several months to deal with that. If you just give us to like the 1st of November to flesh that out, I think we can agree on a questionnaire.
Is that fine with you, Mr. Waters?
Yes, ma'am, Your Honor. We worked together last time to develop this questionnaire, and obviously I think we can do that again. And then if we have any issues, we'll bring them to the court.
Well, I looked at it, I thought it was great.
It worked
Seems
very well.
like it was helpful.
It
Worked
did.
great.
Your Honor, what we didn't address in the questionnaire, and we've got a consultant we're talking to about is, do we ask in that questionnaire a level of awareness about this case? I'm not saying we should, I'm just saying
Right.
we're examining that, and that's why I'd like till the 1st of November. And of course, in the question, if you do a questionnaire when they get here, obviously we want to know a little bit more about their specific knowledge of the case, but so yes, we agree there needs to be a questionnaire. We may want to add some questions to that questionnaire. We're just not sure, but we will be by the 1st of November.
And what we did last time, Your Honor, that worked very well is we had that questionnaire. The parties went through that questionnaire. We actually then had a dialogue where we agreed based on certain responses of jurors to exclude, and so they were already gone by consent, but we already identified ones that would need additional questioning. And then, of course, there was additional questioning with the court and the parties in private for either the jurors by their questionnaire or by responses in court that just needed further inquiry. And again, we were able to do that in 2 days.
And Your Honor, we would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the venire and others did not. She was apparently excusing people, we believe, and of course this litigation could help us, litigation that's on appeal before the circuit, let us develop that. Her daughter appeared on the jury venire, and she, and I guess at the time, either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how she'd make a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again. We've got a new clerk, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before she issues, he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me
Right.
and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions such as over 65 who claimed that were non-residency issues and that sort of thing.
Right, would be my understanding of what normally happens
And when we
pick a jury here.
We had the whole panel arrive. Yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with with Alec Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued. And certainly there were people that the clerk said,
They don't live here, they're over
Right.
65.
dead, whatever, I get that. But if we never got the original list, so we don't know, and again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict, so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? I'm not saying that could happen again, but I think I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen a clerk of court interfere in this process.
We're no. Well, I wanted to, y'all, that Fitz News report they're talking about, where is it? And I've been trying to avoid this. Why is Mandy Matney's name coming up with this Fit News bullshit? I'm searching, guys.
And clearly, our Supreme Court found she did.
Okay. Well, I can tell you, Mr. Harpillion, I certainly don't mind overseeing it.
Thank you, Your Honor.
That's for sure.
And again,
Mr. Waters, I will, wherever this trial is going to be, I will certainly make sure that it is on the up and up. I can promise you that.
And just to be clear, there's absolutely no evidence that there was any shenanigans with that part of the process.
Yeah, I haven't heard of any of that, but, we'll just make sure that everything is done properly.
Thank you, Your Honor. That's all I'm asking. And again, I would agree, we were never allowed to look at that piece of it for our motion for a new trial. It wasn't relevant to that. And the clerk was not going to, she never admitted she talked to any jurors. The court, both Gene Toll and the Supreme Court found her to be a horrible liar. So you have to prove it extrinsically. We don't need to go there. We may go there in our federal case, but we don't need to go there. I'm just saying, call me naive. I just want to make sure you are in charge of this process. And it's not deferred to some functionary.
No, I don't have a problem with that.
Thank you, Your Honor.
All right, the next
Very
motion.
quickly, if I could
Oh,
just
yes.
say that as we got the dumps from the clerk's office with the jurors, it had the numbers on there with the over 65s and had the return from those individuals.
You did get those?
That's my
We
recollection.
did, but the question is, who got off that list before we got it?
Okay.
That's the problem. And do we have any
You
evidence
just
of
want
that?
the original list.
I want the
is what
original
you want.
list, and I want
I understand.
I want you to have the original list. So when the summons go out, you know that everybody was on that summons list was summoned unless you were told they were dead, and again, I'm a little paranoid after our last experience, not realizing the clerk was trying to fix the jury.
Okay. Well, I will, I'll make sure I speak with the clerk before that process.
And Your Honor, certainly Mr. Waters is not vouching for her veracity and truthfulness here today. I understand that we're here because she attempted to fix the jury, right?
Regardless of what you think about Alex Murdaugh's guilt or innocence, we don't need that. We're not tolerating it. I won't put up with it. I don't want to deal with it. No jury fuckery. Period. And I'm not new to Alex Murdaugh, right? I followed this shit from the beginning, right? When they were found dead, his wife and son. I know all about the boat crash stuff. I know all about the cousin Eddie of it all of it. Mandy Matney. I also know about you. And I'm going to ignore you the way I did all that Karen Reed blah, blah, blah bullshit. I can make my decisions on trials based on evidence presented in the courtroom, not what, public opinion's telling me to think. We can have conversations. But Miss Mandy Matney, it wasn't enough to report on the case. Just like it wasn't enough for the clerk of court to be the clerk of court. We got to go all extra. Okay. Well, I can't find a report where Fitz News states that a bullet found in Allendale crime matched this one that, not seeing it nowhere. And defense attorneys do watch social media, and Taylor did it, and the Delphi team did it as well. Of course, Murdaugh's team's doing it. We got to go where the support is, or not, whatever. And we don't mess with the juries. Letitia Stock is even going to get a new trial. Come on. Ann Taylor wasn't wrong when she said, oh, hold on, we got to do a whole bunch of years-long survey. Now I get it, Ann Taylor.
I think he understands. Let me hear from you, Mr. Ward.
Well, look,
I
there
think
is
he
no absolutely
understands
no.
why we're here today.
I went through a lot and actually, suggested a lot of these procedures. Ultimately, all we were trying.
Here's where I stand on new trials. Anybody granted a new trial based on the law? Because that's what it's going to be based on, right? Unless they got new exculpatory evidence, I didn't do it, some other dude did it shit, right? New trials are always based on a technicality, law, something wasn't done right in the first trial. So thanks a lot for costing all the taxpayers tons of money because you couldn't get it right the first time, right? Don't be hiding your Giglio stuff. Don't be hiding your Brady material. Don't do it. Make sure your clerk of court's not fucking with the jury. Nobody's discussing eggs in the background or future books. We're not doing any of that. This legal justice system is costing us a fortune. Haven't you heard? Are we going to continue to take it? No. So we can be upset they got granted a new trial, but remember, it's because error occurred somewhere, right? And we're going to hold them accountable for their error. The error of your ways will catch up with you, sirs and ma'ams. I'm going to let them talk and hash it out while I go smoke a cigarette with my lukewarm coffee.
Recognizing the uniqueness of this case, and there's no denying it, is get a fair and impartial jury. And,
Right.
and the process that we put in place worked very well. That the person who was handling all that and sending out those juror responses, it was, there was multiple staff involved, and all of that was under the supervision of Judge Newman. So we certainly understand what the Supreme Court ruled, but I know Your Honor will supervise whatever process, and my only goal and my only intent is to have the first screening process take place and then give us the jurors that are in play, and then we'll put together a fair process to put 12 in the box.
I agree with you, Mr. Waters. I'll take care of that. You don't need to worry. Neither one of you. All right, next motion is going to be the state's motion in limine to exclude evidence of the polygraph. Let me hear from you, Mr. Waters.
Yes, ma'am, Your Honor. Your Honor, this was just a prophylactic motion in limine that we filed prior to the first trial. And again, the case law is cited in there. I'm happy to detail it for Your Honor, but obviously the case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that in the subjective opinion of the examiner may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those in addition to the fact that they go to the heart of why we have courts and why we have juries, and that's of course for the ultimate determination of the truth of the matter. And so obviously from the state's perspective, if ever there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that that witness and that officer or whatever does not say the P word out loud, and that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that, and we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to be mentioned because, again, it can be hard to unring the bell.
That's right. Let me hear from you, Mr. Harpootlian or Mr. Griffin.
Please, Court, Your Honor.
Sure.
So, generally, Mr. Waters is correct. But, and let me point out to the court, and I'll hand up a copy of the case. It's the state versus Henry Eastwood, which,
It's the Eastwood case? Is that what you said?
I'm sorry?
It's the Eastwood?
It's the Eastwood case.
I got a copy of it. Go ahead.
Was that you?
No, I've got a copy.
So, as you know, if you've got a copy of it, the Supreme Court said there's not an absolute ban. There are circumstances under which a polygraph could be used. Again, it is not a lie detector, but the question is, if somebody was confronted with the fact that they failed a polygraph, did they give it? In this case, did they give it a confession? The Eastwood case, it was a confession gotten. In this case, and we want to argue this more fully, depending on whether or not this witness is called, Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So, the same polygrapher. So, it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel his deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial, which we were shocked by. But should they call him in the second trial, we may want to go into this. So I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
All right, well, let me tell you, anything else from the, Mr. Waters?
Well, Your Honor, just to correct one thing, there's never been any sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but they are never, I never base decisions on them. And frankly, in my experience, I found them to be wrong or for people to indicate DI for other emotional reasons than them to be accurate. This is why they're not ever relied upon in court. The case that they cite is a completely different issue where in that particular instance, the defendant wanted to bring up the fact that he had been given a polygraph and was told by the examiners he was lying as part of his defense in presenting an expert on false confession. And that is nothing that we have in this particular case whatsoever. And in fact, if you look at the cases that we cite in the memo, Your Honor, a prime example of what the Supreme Court has ruled was there was one situation, and give me 1 second, I'll find the case. That would be State v. Counsel, which is the seminal case on that. And in that particular case, there was another witness who took a polygraph on, were you present, were you involved, and DI was shown, deception indicated was shown. And of course, the court said that because a polygraph cannot reliably show truth, it's of no assisting to the jury because it doesn't show anything. So that's a vastly different situation, more akin to what we have here, where the Supreme Court has already said no, than the situation in the Eastwood case, where that false confession and this aspect of it was crucial to that expert's opinion.
Okay, thank you.
Very, very briefly. It was a proffer agreement. In the proffer is, you're going to tell us stuff, and if you pass the polygraph, we can go to the next step, which would be perhaps giving him something for his testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right, he doesn't have a deal as far as we know. And the reason he doesn't have a deal is he failed the polygraph. Now, whether we get to talk to a jury about that 9 months from now is an issue altogether different. But all I'm saying is we would ask you not to issue an order, blanket order, prohibiting the mention of polygraph, although I will concede I would not do that without having the in-camera hearing of some sort and getting clearance from you.
Well, that's going to be my ruling, Mr. Harpootlian. I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you probably shouldn't threaten mistrial. You should sort of threaten contempt.
Contempt. Yeah, you don't want me to hold you in contempt, Mr.
Well, I don't want you to
Harpootlian.
mistry the case.
And I might mistry it if you start screaming polygraph. So without letting me know beforehand. You understand? I want to make sure everybody's on the same page.
I got it. I think I suggested it. I agree with you. I just wanted you to know there are circumstances, and that's one where we may seek to do that. We're not going to do it without getting your approval, and
Perfect.
that may come up in the context of his testimony. He may say something that.
I mean, you never know what happens at trial.
Right.
I'm just telling you, right now, I'm telling you, a polygraph is not admissible. If you're going to bring it up, you need to let me know first, and then we'll have an in-camera hearing.
Thank you, Your Honor.
Any objection, Mr. Waters?
None at all, Your Honor.
All right, then let's move on to the next motion. The next is the state's motion in limine to allow the state's use of the defendant's prior testimony in retrial. Let me hear from you, Mr. Waters. I've done a lot of research on your motion.
Yes, ma'am, Your Honor. Obviously, at the first trial, Mr. Murdoch, who of course had given multiple statements to the police, in which he said he had never been down at the kennels. He had told all his law partners, all his friends, all his family that he had never been down at the kennels either. And obviously, during the state's case in chief, we presented witness after witness who knew him very, very well, saying 100% that's his voice on the kennel video, which again was taken at the scene with the victims and according to the timeline, just moments before they died. And so he ultimately, with the full waiver with Judge Newman, said, I'm going to testify and I want to testify. And of course, right out of the gate, the first series of questions asked by Mr. Griffin on direct examination was an explanation of why did you lie about being down at the kennels. It was the most important issue in the case at that point. Obviously, as a general rule, under Harrison, a defendant's testimony at a former trial is admissible, and I'll get to the statute in a second. And then I'll also, of course, under Rule 804A1, it would be admissible, of course, based on unavailability, assuming that he would refuse to or exercise his Fifth Amendment right at a second trial. The issue, of course, boils down to the statute. And of course, the statute says that the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. And of course, our position in that is that this is the same criminal case. This is not an other criminal case. It's the same indictment. It's the same allegations. It's the same case that we are doing. There's no question that we are starting the evidentiary presentation again from new, but that doesn't change the fact in the plain language of the statute that this is the same criminal case. And we cite
That's the critical distinction for the statute. Either you're in the same case or you're not.
I agree, and we cite Tucker for that proposition. Now, I do agree that Tucker's a little different. It was a death penalty bifurcated case, and that the guilt phase was affirmed and the sentencing phase was reversed. But the court clearly said there that during the resentencing phase, that prior testimony was admissible because it was the same case. Now, the defense obviously argues that because of the Supreme Court's guidance on the financial issues, that ultimately his decision to testify is somehow impelled by that, and we would respond to that in two ways. Number one is the first thing is very clear that the most important reason for him, quote, "I want to testify," is that he had to explain that kennel video, which again was the most important issue for the defendant to testify. Secondly, as we look at the opinion, and obviously I know you've deferred on the motive evidence, and we'll get to that at a later time, of course. But the Supreme Court, while saying that perhaps the trial court let the state go too far with that evidence, the court did say that the court appropriately ruled the evidence admissible under 404 and did appropriately admit at least some of that evidence. So ultimately, depending on how Your Honor rules on that motive evidence, admission of any prior testimony, should the state decide to do so, could be very much tailored to whatever the appropriate parameters are based on this court's ruling as to the extent of that testimony.
Right, I think it would go along with what financial crimes are allowed in at the time of trial.
Absolutely. Absolutely. And the state certainly understands that and is willing to do that. And then even aside from that issue, clearly, whether it's impeachment of this defendant should he testify again, or if the defense were to present a new theory through evidence that would be refuted by this testimony, I think that the law is very clear that then it could be used for impeachment to sort of, if they change tack, then it would be fair game regardless of the issue of the statute.
Okay. Who's going to argue that?
Mr. Barber will address.
Mr. Barber, come join us.
Good morning, Your Honor.
Good morning.
Of course, we oppose this motion on two grounds, a statutory ground and a constitutional ground. And I would like to address the statutory one first on the generally accepted principle that if a constitutional issue could be avoided, that you should rest on statutory grounds.
We don't need no constitutional issues. Good Lord, they need to make sure everything's on the up and up. We're not doing this crazy stuff. They're supposed to be trained professionals. They should know what to file, when to file, and how it all is supposed to work. And I feel like every day it's a lesson in law when they're in court. The judges reminding them of what they're supposed to do correctly, right? Yeah, Chris Watts wants to get married to some lady who wants to get married to a guy in prison. She already applied to get her name changed. That's out there in the media. We have those reports are out there. So yeah, she did. Higgins, I watched the trial too. We're just going to have to agree to disagree on some of the facts. But I know there's a lot going on down there in these small town worlds. I'm from a small town in the Southeast. So I know how shit goes, but yeah, Murdaugh, And everybody involved in all his crazy madness and behind the scenes bullshit all deserve to be exposed. In every small town. Oh, and let's not forget those giant towns like from Massachusetts, right? It's across the everybody wants to go small town stuff. Y'all, Boston, Massachusetts, Canton, like Massachusetts as a whole, corrupt as all get out. And they're not from the deep south. But yeah, there's questions. I get it. Like, did another bullet from another crime match the Murdaugh? Well, I can't find that story nowhere. So it's just a story at this point in time. But we'll continue to investigate to see if we can get there. Chris Watts, go sit down, sir. I don't want to hear anything bizarre about you. I don't want to read bizarre comments. I don't want to read any of it. I'll ignore it and just keep moving on.
And the statute here is 1911-50, which, as Mr. Waters said, prohibits using his testimony in another criminal case. And so we're concerned on what is the same cases versus another case. At 10:23 a.m. in this hearing, Mr. Waters, standing at this podium,
Oh, and I can't ignore that Chris Watts had a lot of fangirls at one time on the internet. I'm just saying.
said, quote, "This is a new case." That was his statement on behalf of the state. On a different motion, he said, quote, "This is a new case." Now, for the purposes of this motion, it becomes, again, the same case. The defense's position is that a trial de novo is another case, that is the logical, rational conclusion from the statute, that the purpose of the statute is to protect the ability of a defendant to testify in one criminal case without a broad, irrevocable waiver of his Fifth Amendment rights. The state, as far as I can tell, takes the position that the indictment number controls whether this is another case or not. Not anything substantive happening in a case. And I would point out that there's not a single case in which, with a trial de novo, because of an error by a state actor, not the prosecution, but certainly a state actor, that constitutes irrevocable waiver of the defendant's Fifth Amendment rights. You know, Tucker is the closest case. As Mr. Waters conceded, it's not really applicable. It's a resentencing on the same conviction. Here we're having a trial de novo, and everything is new. As the court just went through with all those other motions, it's a new case. Even the protective order has to be redone. Everything is new. All the motions in limine have to be redone. The one thing that is eternal and cannot be changed from the previous trial is one witness's decision to testify. That Fifth Amendment waiver is the only thing, according to the state, that's not waived. For purposes of the statute, we suddenly become the same. And before getting to the constitutional infirmity of that, as Your Honor knows, we filed a motion to dismiss the indictment shortly after this motion. It was responsive to this motion. If the state, it's a reductio ad absurdum argument. If we're really going to take the position that it's not a substantive question whether this is the same case or a different trial, well, if it's the indictment numbers under thrift.
Oh, Alex, like, pass me the papers. I'll tell y'all how to conduct this shit. I'm a lawyer. Hey, y'all know that crazy ladies exist, like, legitimately? Do y'all know that when that Night Stalker guy went to prison, y'all know how many women were falling all over him and couldn't write him fast enough? How in love they were with him? It ain't nothing new. Chris Watts, enjoy married life with your newfound lady. Lady, enjoy your married life with your newfound man. From prison. You fucking idiots. What? Of course the lady ain't playing with a full freaking deck, y'all. She married a man who's doing life in prison. What's he gonna do for her? You gonna comfort her tonight when she's feeling sad and lonely? Is he gonna give her love and support? Is he gonna offer financial assistance to the household bills? Hell no. She's giving it all to him. I can fix him. Okay, lady, you do you. Have at your little marriage. I don't care. Weirdo. You getting your conjugal visits too? Do they allow that where Watts is staying? Or does he get his own in the cell? Oh, Bubba behind him?
We clearly meet the standard under thrift for dismissal in the indictment. Now, is that a waste of the court's time? I would say yes, because they'll just go.
Ted Bundy asked a woman to marry him in court, didn't he? There are women lined up to write these men letters. These poor, pathetic women who can't go to the store and meet a man, or to the church, or to a neighborhood outing, or through one of their friends, or from a guy at the workplace. We got to go to prison to find love. Okay, we'll see you on Love After Lockup or whatever.
Go to a grand jury and re-indict it, but if we're going to put substantive import on the indictment numbers, the arbitrary indictment numbers, well,
Y'all, it's sick. It is gross, but at the same time, what's wrong with those women? Like, fucking for real? You got to ask that question. We're discussing mental health. What's wrong with those women who think that that's cool? Poor souls. Get their baby doll next.
grand jury, we have testimony from the first trial that the grand jury was presented evidence that the state admitted in its reply closing argument was incompetent, which the witness also admitted was incompetent. We have, if you look at that very lengthy motion for sanctions that's still pending, it's a colorable claim of misconduct. I would point out in Thrift, the Supreme Court explicitly held there was no misconduct, but because there's a colorable case for it, which is the least possible burden, well, fabricated evidence is a colorable claim of misconduct. Okay, is it prejudicial? Well, it would be the only direct evidence linking the accused to the crime.
Thank God, because that man shouldn't father any more children. Period. Like that lady is probably, thank God he's not getting conjugal visits. They probably should make sure he doesn't get any. We don't need no reproductive systems at work in overdrive. What if she gets the postpartum afterwards? Who's going to take care of the baby?
Direct forensic evidence, something that would prove his guilt, that must be prejudicial. So we meet the Thrift requirements. The indictment should be dismissed. They should have to go back and re-indict it. We'll get a different indictment number and be right back here with a different case if that's really their position, that a trial de novo is not another case. And this is just a statutory argument. There is, of course, a constitutional argument, which is the Harrison argument, which is that because he was testifying to address evidence that was ruled to be inadmissible, that his Fifth Amendment waiver cannot be held in this new trial. I mean, that's the clear holding of Harrison. Clear holding of Harrison. It clearly, in Simmons as well, which was a suppression hearing. That in that case, someone testified in a suppression hearing, and electing to assert that Fourth Amendment right in a suppression hearing.
He's boring. Even I get what you're arguing, but you're just boring about it. Like, I'm not. We fast forward through him. 10-second visits. What can you do in 10 seconds that's nasty or not nasty? What are we doing in 10 seconds? What's happening?
You're not required to waive other constitutional rights. The case law clearly holds, and Your Honor indicated that you've done a lot of research on this, that a witness cannot be required to surrender his constitutional rights to address.
Yeah, so if y'all saw it on Jay's stream, would y'all look up the shit from the prison and see how these visits actually go? If they're getting 10 seconds to hug by, or what are they doing in that 10 seconds that could be so nasty? Oh, good Lord, it don't take long, does it? Jesus. Fuck.
Inadmissible evidence. And I think Mr. Waters agrees with that, in that the dispute is whether or not he was testifying to address the financial crimes evidence. But as our response motion, with many quotes and block quotes, that was explicitly preserved. In Harrison, it was just an inference. In this case, counsel repeatedly put on the record why he was testifying. On page 3 of our response, Mr. Harpoolian said at that time, quite explicitly, put on the record that our advice as to whether to take a stand or not would have been different had the financial crimes information that he was also renewing the objection to had not been admitted over objection. And the court held in response to that the objection was preserved. So here we are. Harrison directly prohibits this, though I would suggest to Your Honor.
Okay, But what can they do in 10 seconds? Y'all, I'm a grown woman. I get they can touch and hug. But what are we doing in 10 seconds? Are y'all a 10-second typer? Are y'all good to go? I hate it for you. But hey, they're in prison. The 10 seconds may be all it takes. Shit, I ain't been to prison, so I don't know. Lord, if y'all got a man that only takes 10 seconds? Jesus. My man is good to go. 10 seconds later, we are done.
That the statute would be an easier ruling because there's no reason to reach a constitutional question. This is another case, which we just said a dozen times when discussing previous motions.
Thank you.
Thank you, Your Honor.
Any response, Mr. Waters?
Very briefly, Your Honor.
I'm not doubting what y'all heard, Faye. I'm making fun of it, right? And hey, if they get their 10 seconds, I believe it. I'm just saying, what are they going to do in 10 seconds? Come on. That's what I'm saying. I'm not doubting the reporting that y'all saw. I'm saying, what the fuck can you do in 10 seconds? Let's be honest. I don't want a man that can be done in 10 seconds. Jesus Christ. It's already bad enough. Jesus. 10 seconds. Hey, that might be a blessing sometimes, though. Like, you good to go now, bud? You're good? Fine, leave me the fuck alone. Hit me back up tomorrow for your next 10 seconds. Jesus.
First of all, just because I just got this from General Counsel at SLED, that there was a 300 blackout that was used in Allendale. However, it was entered into IBIS, and there have been no leads or no matches on that. So that's what I was just informed.
Is that going back to
The prior motion, yes.
the prior where the blackout was
And I'll find out more, but it does.
said to have been used in another murder in Allendale or somewhere? You understand that, Mr. Griffin? Okay. You know, sometimes a real novel idea is to pick up the phone and call each other and talk. That's what we used to do when we were younger. Just call and ask if you've got a question, and then if you have a problem with it, I'm more than happy to settle it for you. I hate that we have to do this in court. I do. It's easier just to, now we can email you if you don't want to talk to each other. You just email each other.
That's a novel idea. You just told grown-ass men they could email each other if they don't want to talk to each other. Jesus Christ. Men, if y'all don't want to talk to each other, you can just email one another. We don't even got to have a trial. Just we'll email the whole trial. We'll do that. Y'all good? All right.
Say, hey, you heard about this?
I've never not taken a call from these gentlemen.
I'm sorry, y'all. This is kind of a relief after the heaviness of the Clancy trial we've all been watching day in and day out, and how horrendous that's been. Y'all get along, all right? Throw some whiskey in the fucking coffee and calm down.
Love talking to them.
Yes, sir, Mr. Harpelian.
Did he shabugs on everything? I don't watch that shit. I watch it from afar. It turned into the shit show quite immediately, and a whole bunch of other stuff that I just like closed my eyes to. Didn't want to look at none of it. I just see the headlines as I'm scrolling through the social medias of it all. Nice, good.
He loves talking to me.
I did.
He did.
Maybe that won't put the rest. That won't put any naysayers to rest. It was probably a false confession. You know, they read-techniqued his ass and got a false confession.
So maybe you ought to pick up the phone and call him.
Maybe they need to start drug testing it. December 7th.
Whoa, we are laughing about drug testing? We got to do some what? They're all laughing about it? Can we get the alcohol test too? Y'all looking for weed? Y'all looking for pot? Can we get the alcohol blood alcohol level? I would love to see those at the end of the night. They matter. Did you hit the whiskey? Did you have a mimosa before trial to calm thy nerves? Totally acceptable in America. Totally.
From these gentlemen.
love talking to him.
Yes, sir, Mr. Harpelian.
Did he just say he loves talking to me?
I did.
He did. So maybe you ought to pick up the phone and
Or
call him.
maybe they need to start drug testing it. December 7th.
Wow.
In all seriousness,
Seriously, though, seriously. Are they all here for their own 15 minutes of the next 2.0 15-minute version of themselves? Let me go back and review what I did last time at 1.0, and I'm going to change it up for 2.0. Or we got a shit show unfolding in front of our hands. This court's going to be fucking wild. Gee whizzikers.
I have never questioned Mr. Waters' integrity. But as a result of this case, I cannot help but question the SLED lab integrity and the SLED agent's
I
integrity.
understand, but see how easy it was for him to make a phone call and turn around and give Mr. Griffin an answer.
So, okay, and the answer is SLED entered it into some database and got no matches. Did they pull the shell casings from the Murdaugh trial and compare them to the shell casings to this? And that's not what I heard. That's not what I heard. And remember now, and if you've read the sanctions motion, they misled Mr. Waters about the blood spatter for months. And misled us, and misled an expert. That was the SLED lab. And when we talk about DNA in a little while, that's the context in which we are approaching this case, because we were lied to, the grand jury was lied to by SLED, and he was lied to. So I appreciate the fact he calls, and I was a prosecutor for a while. Trust, but verify when dealing with police officers.
Well, I'm sure he'd be happy to do that for you.
I think I have personally been involved in the indictment of 7 sheriffs and multiple police officers. If I had any evidence anybody intentionally fabricated evidence, I don't play that.
That's a lot of cops to prosecute. Hold on. Y'all, that Luigi matter's a little complicated on the court level, but he's pled, because that's why I asked pled guilty to what, because I knew there was the stalking charges, and that's what he was pleading guilty on. I knew that was on the table, but there's still other. We'll get to that. We'll do an update in a minute.
There's a difference between, Mr. Harper, excuse me.
Let him finish.
There is a difference between where mistakes or the 2 ships passed in the night and intentional fabrication. That might be their characterization, but that's not what the evidence reveals, and obviously that'll be something that we'll discuss later on. But I will obviously look into that more, but IBAN is the database where you put guns in, kind of like the fingerprint database, and then it gives you hits whether it shows up with other crimes.
Would it show if you put in the casings or the markings from the casings?
I'm going to find out more and double check, and we're going to run this down. But again, there is no, from what I was just told by SLED, there are no leads or hits on that blackout that was used in the Allendale shooting. I promise you, though, that I'm going to find out more.
And if you got any other questions, Mr. Griffin, just email him. He'll check it out for you.
Sure will, Your Honor.
And I mean, if you want some kind of verification, I'm sure he won't have a problem giving it to you.
As long as, again, a phone call between him and an agent who has a stake in maintaining this conviction is okay for him. It's not for us. We want to see if they submitted it, what was the result? Is there a written result?
And what I'm trying to tell you, Mr. Harpooling, is just ask him. I think he will give you just that.
Okay.
And instead of just throwing all these questions at him at one time, just send him an email. And if you want something verified, tell him. Do you have a report to that? I understand you being distrustful. I got it. But if he doesn't know what you want, he can't give it to you.
We'll be explicit. Thank you, Your Honor.
Yeah,
All right, let's go back now. I'm sorry about that, Mr. Waters. Let's go back to the defendant's prior testimony in his retrial.
Sure, and just to start out, he said at 10:23, I said new case, and I think he's parsing my words a little closely when I'm talking about Your Honor's reconsideration of a ruling. It's still the same indictment. It's still the same testimony that under oath. It's still the same evidence.
Oh, I get that, CH. I like Emily D. Baker. I don't watch her as much as I'd would like to, I guess, because I'm always watching so many different things. But I do go to her for certain things. Like, I just like her commentary. But I get it. I'm not shocked. I mean, I get all that workplace stuff, but to do it in the open courtroom like that, that's what I find odd that they shouldn't do. That's not professional. Oh, maybe they should do a drug test. What, because you can't talk to each other? Now I can't take y'all seriously. Really? Y'all just that's where my mindset goes with stuff like that. All right, keep it at the water cooler level, not in the open courtroom. Thank God juries don't have to hear all that shit. That's why judges are like, excuse, no, 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 we're not having all this chaos in my courtroom. The jury is present. The jury's present. Y'all calm down.
That's going to be presented, it is the same case. And while Tucker is a bifurcated proceeding, it still was a brand-new evidentiary proceeding de novo in that particular case. So I think Tucker is still applicable. Ultimately, again, I think that the appropriate solution is going to depend on your Honor's parameters as we get to that financial evidence. But ultimately, the Supreme Court said, we agree with the state that under the facts and circumstances in existence in the first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404, and went on to say, we hold the trial court acted within its discretion in admitting some evidence of his financial crimes. So that issue was in play. So it is not going to give them sort of a complete out, unlike Harrison, which I believe was a completely false confession that was played on TV and for everybody to see prior to trial. The financial crimes, according to the Supreme Court, were appropriately in play. The only issue was to an extent which Your Honor and the parties can clearly circumscribe that based on Your Honor's ultimate ruling as to those issues.
Okay. All right, I did, Mr. Barber.
Your Honor, just very briefly, we anticipated the argument Mr. Waters just made on page 9 of our response brief. It is under Harrison, it is the state's burden to show that its action did not induce the testimony. So this idea that you can parse out that they could have introduced some unknown quantum of financial evidence, we don't know exactly what would have been admissible or not, and maybe that quantum would have been admissible and therefore not triggered Harrison or Simmons. It's the state's burden to say that what they introduced did not compel his testimony, and simply saying that we perhaps could have introduced something is not sufficient to meet that burden.
Okay. All right. Well, I've read the case law. I've read the statute in this case, and I think it's pretty clear. A criminal defendant's testimony from a first trial is admissible at a retrial in the same case, and that is from 1911-50. The testimony of a defendant in a criminal case shall not afterwards be used against the defendant in any other criminal case. That is, our Supreme Court interpreted 1911-50 narrowly, and it limited its protection to the use in a different criminal case, not the same case. So I believe that his testimony may come in under 804. I've got B1 or A1, I think it's B1, or for impeachment purposes. The court does not find the defendant's argument prevailing. I think you rely heavily on Harrison versus U.S., where the defendant was forced to testify as a result of the prosecution using illegally obtained confessions by the defendant. Here, the defense argues that the evidentiary decision of the trial judge to allow evidence of the financial crimes coerced the defendant into testifying. However, I went and looked at the ruling again from our Supreme Court. The court ruled that the evidence of the financial crimes in this case is admissible in the new trial, so long as it is probative to the murders. Accordingly, this is inherently different as an evidentiary issue versus illegal conduct. Now, with all that said, I don't know, Mr. Harpootlian or Mr. Barber, what the state intends to introduce as in their case in chief. I don't know what financial crimes are going to be allowed in and what's not going to be allowed in. If it's not allowed in, certainly that testimony related to it. I mean, it's all subject to rules of evidence. If it's not relevant, it's not in your case in chief, then it's that prior testimony is not coming in. Obviously, I think you agree with that.
Yes, ma'am.
But I do think, there's when you testify in a case, there's consequences. Testifying and not testifying, there's consequences. You don't get to tell your story, but then you're also at the peril of cross-examination, and it's sworn testimony. So I'm going to allow it in, subject to what is being testified to in the trial. Okay?
Your Honor, for the record, we would respectfully
Disagree?
disagree. Are you going to issue a formal written order, or is that your ruling?
That was going to be my ruling.
Fine. And of course, we would renew it when it becomes relevant, but I just want to make sure we're not perceived to have waived an objection to that.
Sure, I'm not going to let you waive any objections. You can take objections to all my rulings at the end if you'd like, and we'll put it on, it'll be on the record. We'll revisit it again at trial.
Thank you, Your Honor.
Okay. All right. Now, let me go to the state's motion as to the privilege review of the defendant's phone and the motion to compel defense to turn over the digital evidence.
Thank you, Your Honor, and may it please the court. Just to kind of set the table a little bit, and I know we have done so in our motion, the night of the murders, Mr. Murdoch, although he was referring to his phone saying, see, hey, I called Maggie, see, I went, at that time, the phone was not downloaded. It was not until 3 days later on June the 10th that actually a 14th Circuit investigator, who's now in an advanced logical download of that phone, of course. And so there was that. And then later on, after the side of the road happened, or I think it was maybe in August, then his phone was seized again, and there was a download done by SLED at that point, okay? Obviously, he's a lawyer, and like any case where we have a phone, but particularly one where there's a lawyer involved, we had in both instances, the first one was done prior to the Attorney General's direct involvement, but there was a privilege review done in order to protect the rights of the defendant, right? And so ultimately, the investigators only and the prosecutors only received the redacted parts of that phone, whereas the defense always got the unredacted copies with everything on it.
Right.
Same thing happened with the SLED download. It was privilege reviewed by a taint team at SLED, and then the investigators and prosecutors only got the redacted portion, of which thousands of messages were excluded. The defense got the unredacted portions as well. So the first part of this motion is, and I believe they consent, so I'm not going to talk too long about that, is that since that time, of course, there's been a number of developments, and we painted a broad brush because, frankly, Your Honor, the last thing in the world I want to do is to become privy to some communication I'm not supposed to. In fact, we go through great lengths to ensure that doesn't happen. But we've since had, I think, 12 attorney-client privilege waivers from former clients of his. He, of course, has pled guilty to conspiracy with another lawyer and a banker. And so those things, I think, would require a reassessment of that privilege because of either attorney-client fraud or these waivers. And so we proposed to do that with the taint team. And then we also proposed, and I think they agree to this, that we would identify new communications to be released to the prosecution and investigative team, but give them a chance to review those without us seeing them and make any sort of issue they want. And if there is an issue, we'll bring it to the court.
Are these waivers, are they affidavits, or what are they? Or
Yes, during the course of the financial investigation, many of the clients executed written waiver, attorney-client
okay, so there's a
waivers.
written waiver from these clients.
That's correct. Yes, ma'am, Your Honor.
Okay. Any objection to that being sent back to OGC and reevaluated?
No, Your Honor, we don't object to the process that was described in Mr. Waters' motion, where the team would bring to our attention and the court's attention any potentially privileged stuff before the prosecution receives it.
Okay.
All right, the next part of this is that early on, of course, we were told that there was a defense extraction that had been done. We've now, since their response, they've said that it's a logical extraction as opposed to a full file extraction. The thing about phones is that they really represent a snapshot in time, right? They are, I hate to use the word breathing, but they're sort of living items where the evidence on them can change through manipulation of the phone and just how they operate from one day to the next. And so ultimately the defense had that extraction. We never asked for it at the prior trial. They, of course, never used it and didn't call the examiner who did that. And so we filed this motion to ask for it. I think, for the sake of right now, I think the defense has raised these constitutional objections while we have our arguments where we believe these things can be authenticated other ways and that there would not be an act of production Fifth Amendment violation. At this point in time,
I tell you what, they need to start getting a little more serious about how they're handling cell phone and cell phone data. Why haven't they given Karen Reed back her phone? Why does Kaylee Gonzalez family not have her phone? Why was Libby's phone given back to the family, then took back again? And years later, as new technology develops, we're doing all these things to these phones. They better stop it before the Supreme Court puts the brakes on all of it.
I'm going to state that that I think a better solution might be, because under Rule 5, of course, their disclosure obligations require them to disclose those if they plan to use them in their case in chief at trial. The problem, that, as I see it, and why we ask for this, is that those things can't really be easily assessed, overnight, right? Because they are very large. And so what I would suggest and request of the court is that, and I understand that during trial things can change, but that there be, and ultimately there a scheduling order whereby, at least as this issue, they can declare that intent, or at least give this information if they're going to use it to the state in a reasonable enough time prior to trial, so that we're not broken down with a jury on ice, so that we can assess a phone dump of 256 gig phone.
We don't need a jury on ice while we're analyzing 250 blah, blah, blah phone data. Well, that phone data is huge because there was a video recorded at the dog kennel. Good God almighty, they better stop it. Put that little bitch in a Faraday bag the second you seize it. Get it to the lab for a forensic download. Then allow the defense to do their forensic download. And then you stop. And then you analyze your downloads with your little experts, and then you march their tails into court and let me decide which one I'm going to believe today. Because I heard different things from a Celebrate testimony yesterday than I heard in the Karen Reed trial. A little different, little differences there. Already got side-eye on your phone data already. Don't make me go deeper.
All right, so you agree that they don't have to turn it over to you?
Simi, if you watched the Delphi trial or tried, you would know. It's always evolving. That's not the problem. The problem is what they're doing to these phones in the meantime. That's where the problems occur. Was there a headset plugged in or not? I don't know. Depends on which expert I believe and who Googled the information first. Houston, we have a problem.
Unless they're going to use it in their case in chief.
I think,
unless it's provided that it's not protected by attorney-client privilege. It's not protected under the Fifth Amendment.
well, I think what I'm saying is we raised arguments as to why the Fifth Amendment would not apply in this case, why attorney-client privilege and work product would not apply in this case. And again, we're not asking for the opinions of the examiner or the impressions of that. But what I am saying is at this point in time, given their consent on the privilege review, am not willing to, push us into this particular thorny issue at this time, as long as maybe we have a remedy that if they are going to use it, it is provided to us in
You
sufficient
want
time.
notice.
That's correct, yes, ma'am. I think that's a
A thorny issue. We got more than a thorny issue.
fair resolution.
Any problem in giving him notice if you're planning on using anything from this phone in your case?
No, Your Honor, we didn't use anything the first trial because the full extraction the state did less than a month later has, that and more. So I don't anticipate that we would use it at all, frankly. We didn't.
So nothing found outside of what the state found. Well, what the state's got more in it. Ours didn't turn up shit. We don't need it. Okay, problem solved. Let's move on.
Well,
I have no issue with giving notice if we change our mind.
well, let me ask you this.
Yeah, that crime, Simi, so that crime happens, right? 2017. Why were they still testing that phone all the way up to trial damn near? And no, there was a lot of problems with the phone data in Libby German's phone. So we're going to be doing some shows about that coming up soon.
I set the trial for April the 5th, and I intend to stick by it. How about, if you're going to use anything, can you turn it over to him by March 1st? That'll give you like 30 days to have any rebuttal or expert witness or any objection to that?
If Your Honor if this is only about the Chip Johnson cell phone extraction that we're talking about, if that's what's subject to that notice requirement, there's no objection.
Thank you, Your Honor, that's absolutely acceptable. The only other thing I would just ask, and I'm sure they would do that anyway, is that as we work out these issues, that any extraction be preserved during the course of the year.
March 1st deadline. Okay,
I
March
think that
1st.
takes care of that issue, Your Honor.
Perfect. But we're just going right through these. All right, let's,
Thank you, CH. I think I might just leave that right there for eternity. Because I watch so many cases, I know that what the problems are, right? That's coming through the pipe, all through the appellate courts and through this, going to be moving through Supreme Courts. That's why I questioned IGG in an open investigation concerning Brian Koberger. Y'all wait for it. But, what do I know? Just a little old girl on the internet with 3,000 subs. She probably don't know nothing.
talk about the DNA.
And I true crime all the time with a little shade thrown in when it needs to be.
This is the defendant's motion. This was brought up at the status conference. The way I left it was to find out if there was any a viable sample to test. And I want to make sure I got this right. It looks like there was really two samples. A sample the state tested, and there's some leftover, for a lack of a better word, leftover stuff. I don't know that it contains all DNA in it, but leftover. Then there's a reserve DNA sample. So I want to make sure, because there's two. Am I correct in saying that?
Yes, ma'am. So these are, of course, the fingernail clippings.
Right.
And so you got the clippings in the package. As I understand it, a representative sample was prepared and tested. And from that, there's 47 microliters of extract remaining. And testing can proceed from that. There is also, though, the reserve portion of that sample itself that has yet to be processed, which
The same sample.
the same set of
Same-
fingernail clippings,
Right.
but it's kind of like a shirt, or pants. You get the pants, you do cuttings from it. You don't cut the entire thing, and so there's still parts of the pants that could potentially be cut and tested and that sort of thing. So it's very
Right.
similar. So we have extract, and we also have the unprocessed.
Okay, so not all the DNA from under her nails has been tested. We got some leftover that we didn't use, and we got a reserve sample For what? We don't, just to preserve everything. What if Maggie, going about her day, didn't thoroughly wash her hands, as millions of Americans apparently do, and touch DNAs everywhere? It could be a DNA from anywhere, right? It could be the grocery store bagger. It could be the girl at the hair place. It could be the pharmacy. Okay. We need every. But wouldn't you think that if the sample was there from a nail clipping and you test it, there's gonna be a lot of DNAs in there, maybe. It's weird. Okay, well, let him finish. Maybe I'm missing something, but leftover DNA and reserved sample.
Process sample. And so what we have, and we've had a discussion with their expert, and he said, that's barely even a mixture.
But he's talking about the leftover stuff though, right?
He's talking about the remaining extract, correct?
The leftovers.
And we're willing to let them test that extract, even though he says it.
The leftovers.
Correct. But what we would want is
Every time he says extract, she's like the leftovers. Let's clarify, sir. That whole extract you didn't test, you had some leftover DNA. Did she get her nails done that day? I can't remember. Good question, Simi. If she got her nails done that day, hell, it could be a random lady's DNA under there. If the nail tech didn't clean everything properly. I don't know. I don't go to the nail techs. But I'm about to be my own nail tech here in a few minutes. Maybe. If I decide to.
At least some recognition to them, because he said it's going to be consumed, that's going to be gone. We have preservation of evidence requirements and all the rest of it.
Are we still talking about the leftover stuff?
And then on the unprocessed.
The leftover stuff, sir. Oh, Aussie, I'm proud of my 3,000 subs. You know why? They're organically gotten. I didn't build my channel on the back of one case or victims. I didn't run relentless content to get everybody in and keep you coming back. I just go true crime in all day, right? This is happening. We're covering it. If the people come, they come. And I appreciate the ones who do come to talk about crimes, right? It's not a fun place to be a lot of times, but we do it. So I appreciate those who do come back for it. And I appreciate each and every one of y'all that are here. And if you are here and you do come back and you do enjoy the content, please hit the subscribe button. It helps little old channels like me shoot out into the algorithm so I can grow organically. I want the right people in the community for the right reasons. So I'm good to go with small, slow growth. That was my intent, and y'all will see it reflect in my titles and my thumbnails.
Processed. What we have said is that we will process and quantify that and then stop, okay? And at that point, we will know the quantification. We will also know the likelihood, which is highly likely, that there will be leftovers from that, from which the defense could have that as well. And so we're willing to do that in conjunction with and in discussion with the defense and their expert, which is an extremely fair way that all parties have access to all.
I read your motion. I was just, Mr. Griffin, you arguing this?
Yes, Your Honor.
I just wanted to make sure that they're willing to give you the leftover stuff. That's how when I read it, I'm like, okay, there's 2 DNA samples, are all from the fingernails. They want to give you the leftover stuff, but then they want to go and do a quantitative test on the unprocessed sample.
Correct.
And then decide what to do with it. If maybe y'all could share it,
Right.
Or do I have to give it all to you?
So in that conversation, we asked, to what end do you plan to use it? And we've gotten no answer.
Okay, well, I'm gonna get to that in just a minute.
And so our expert says the whole quantitative analysis, it I mean, it does consume some
CH. I love a good meatloaf. It's comfort food in my world.
minute portion,
Yeah, you're right.
so they would be consuming the minute portion. At Othram, they do the exact same thing. If they got, and to be clear, Othram
Y'all, be careful. He said Othram. Don't have a meltdown. Don't panic. I'll show you some stuff on Othram tonight, but not what you think. Maybe that'll get the crowd in there. She's going to discuss the Othram people. Not the way you'll think. Here comes Othram again. Close our eyes. David Middleton, whatever the hell your last name is. Did you shoot yourself in the foot with your little PR campaign that might be backfiring in your lovely little face? PR campaign to beef up my DNA database, one swab at a time, using all those poor lonely souls from websleuths.com to make it happen. Shoot yourself in the foot with your publicity stunt, sir? You're seeing it, aren't you? You're feeling it. I know it.
has in the past, and I'm sure will in the future, they receive DNA samples from SLED. They're in chain of custody. They have routinely test
From our lab,
from, yes.
so there is a way, because that's one of my questions,
And so, and they're
to maintain a chain of custody.
absolutely certified to do that. They do that with law enforcement around the country. And Your Honor, I've just watched recently the Idaho murder
Yeah.
documentary.
Oh, oh, God dang. He ain't about to go there, is he? All right, here's the thing. Othram did no wrong in the Idaho 4 case. There's a lot of shade being thrown at Othram because of their affiliation with websleuths.com. I could have a whole show on that alone. And now nobody wants to hear a word about Othram because of the affiliation with websleuths.com. Othram's just Othram Labs, trying to make a DNA databank bigger and legal, because the FBI gets all the work when we have to stop our work because we've met our legal requirement, right? FBI can do a lot more than we can do. We need all y'all's DNA to beef up our data bank, so we ain't got to let them have at it. We want to have at it. Othram was solving so many cold cases. All they do is develop an S&P profile from an STR DNA sample, and then they start their IgG work. And yes, it was a huge deal in the Idaho 4 case, but they did not find Kohberger. They only found relatives of Kohberger's, but we'll let him talk about it now. And I've got the documents from the Idaho 4 case and Othram, and we'll be going over that tonight. Wink, wink. Let's put that out in the universe. Ooh, Idaho 4 show. Can we compete with all the supporters of Kohberger?
Very
I
young.
watched it.
But, Othram is right there. I mean, they are the lab who does this. And it's
That was going to be my next question to you. I mean, are they an accredited facility?
100%.
Yes, they
I
are.
just can't be handing over DNA to somebody who's not
They,
accredited, and they
She's asking, what about this Othram? Are they accredited? Well, we can call up that Trisha lady and ask her. You suggest it, Murdaugh. Hey, I know this lady named Trisha, old bat in a hat. She got some woo-woo. But she says that Othram man, that dude's pretty good. That gig is sweet.
know what they're doing.
and we were on the phone with him, and he says, we work with SLAD Lab, and they receive samples from them. They do that work. They do work, on behalf of cold cases around the country, and they do some work on behalf of the Innocence Project. And so they are.
And they participated in the first investigative genetic genealogy investigation into an open, active murder investigation. Not their fault. They just got sent some samples and said, hey, do your magic. And they're like, well, we got some relatives. FBI said, hold our beer. We got Jennifer Coffindaffer. Oh,
certified, and there's been no dispute about that. And they, what Dr. Middleman says is, what's their scientific purpose for doing quantitative analysis? What are they going to do next? Because we'll do quantitative analysis, and we'll share that with them.
quantitative analysis. We got so many labs scattered across this country now performing DNA magic everywhere, not just Othram Labs. We got Sheriff Nanos will come out and tell you, hell, we got DNA slung all over the country trying to figure this mixture out. I'm about to go to the Supreme Court with all this. When are we going to the Supreme Court with all of this? If y'all gonna be doing genetic genealogical testing, y'all should probably visit the whole situation and how it's done. Ann Taylor's got tons of information on it. She was able to get it through subpoena power, a TUI request with the FBI. She was handed more information on genetic genealogy than any other attorney had been at the time.
And then we'll give everything back to them when we're done.
And we're talking about the unprocessed.
Both. We're talking about both.
Both.
So there's, leftover extraction that was processed,
Right.
and we want to test that. And then we want to have the unprocessed.
Othram was 2024 when they became accredited. Well, I know in November of 2022, and then all of 2023, Idaho was already under contract with Othram, right? Kind of like Pima County was already under contract with the Florida lab. That's what, every police department has that lab they're affiliated with, where they send all of their stuff to. So Idaho was already in contract with Othram, and that is the only reason Othram got that DNA to work on. Otherwise, it would have went to any other lab they were already on board with working with, right? It could have been the same Florida lab that Nanos deals with, but it happened to be Othram for Idaho. Because everybody's like, why are they sending shit to Texas? That's where the lab was located, right?
To do a quantitative analysis and then include that in the testing. I mean, and the question is, if you're doing STR analysis of the same DNA sample, why do you think anything different is going to happen? I mean,
Well, let me ask you this. If Othram is willing to process it,
yeah, absolutely. Quantitative analysis and give it, before they do it, the next step. I mean, we'll do that, and we'll share it with them before we do anything further.
is there, can they do the other tests, the STR testing?
I'm confident they do STR testing
They can do the STR and the SNP.
and the SNP testing. Yes, they can.
Huh.
And that's what.
And we also,
And let me make sure I got this right, because the SNP is really different from the STR. Those results are based and compared against, like CODIS, known samples.
STR is.
The STR. The SNP is a bigger, I want to say a bigger database, because it's
Well,
genetic. So like all the people who
23andMe.
23andMe and all the other.
If you or I or
agencies.
anybody in the courtroom gets a sample, submits it to 23andMe, that's a SNP analysis, and that uses a whole lot more of the genome, a whole lot more of the DNA.
Not that it's going to give you the one individual, but what it might give you, and no guarantees, is a family tree that you might can trace back. Is that right?
Absolutely.
Okay.
And in addition, what Othram can do, so we do know that this sample, this is male, the unknown male. So there's Y chromosome in that sample. Othram can test and analyze that Y chromosome, and depending on how much it is, they can go back to origin. Like, is it an Asian? Is it a white male? Is it, and they're able to do that.
But will it yield a name other than some relatives? They can't even find who the porch guy was in Nancy Guthrie. If the people aren't in the legal databases, you're not going to find them. You might find some people that are connected via their DNA, right? That's what they're doing, searching everybody. Broad warrant now. Now you're all being investigated because you all share some DNA. Not mad at it, but we need to be careful.
And so they have so much more capacity than the SLED lab. And it's expensive, and we're wasting time. And
Thank you, CH, because the judge misspoke about that, and so you're trying to help clarify, and I appreciate you.
we want to pay for it, and we want to get on with it.
Well, I already told you I'd let you pay for it. That's a given. That's gonna happen. How long is it gonna take them to do it?
Well,
Oh, he's already talked to Othram. You already can bet that sweet ass the second he heard all this Idaho 4 chitter chatter and the Othram, he called that guy. Can you test this unknown DNA, male DNA from underneath Maggie's fingernails? He's like, yes, I can. How much will it cost me? Well, hold on a second. Let me ask my wife.
we put in our supplemental memo that it would take 60 to 90 days. I mean, honestly, he says, we'll make it a priority. We can do it in 60 days. And I said, well, how about, don't say that. Let me say 90 days.
He said that. David, my pal, old buddy of mine. Come here, friend. Come here, friend.
But what we'd like to do is have it all at one time so we can do it all at one time.
I understand that. But let me ask you this. What does your expert say about having something left over that they can give and share with the state? Do they think if they had it all, is there something going to be left over to give to the state? So they want to do their STR test again.
So we would know that, Your Honor, after the quantitative analysis that we would like to author them to do. And then we would like to share that with the SLED lab. There's no reason, because they're doing the same thing.
Okay, generally when the DNA is found and they get the S&P, right? In that, right, the S&P, right, CH goes for the CODIS, right? No matches come back to CODIS. Then we go and develop the STR from that, or the SNP profile rather, right? We develop one from the other. And then that's when the IgG starts. And like CH was explaining, that other profile has so much more information. Not that the database has more, but the profile does. The origins of the person and all the those things, your makeup. And then they're searching for matches that share the same, not all this, because we're all different DNA. How much does each test cost? I don't know what Othram charges to develop the profile and do the work. I have no clue.
And
that might be in the documents I have later for Idaho 4 case. I haven't went through all of them yet.
And Othram says, why?
Well, if you're going to share the STR results, you're going to share the SNP results?
Well, Your Honor, I didn't say I was going to share any results.
Oh.
I mean, I said they could do.
It depends if the results are exculpatory to my client or not. Okay, yeah, STR is CODIS and CODIS alone. And the SNP is for the IgG. And they upload the STR profile to get the CODIS hits. Thank you, CH, because I this morning my brain's like, which one is it? I forgot. $7,000 to $10,000. Well, that ain't bad to see if I didn't do something. Like, can you prove that's not my DNA? Thanks. Could be my cousin's, though. Hell, I don't know. Did y'all piss her off today? Joke.
Do that. The rule doesn't require us to share results of scientific analysis unless we intend to use it.
Yeah.
But
Right, I agree with you on that. But I'm asking, if they wanted, you volunteering to do the STR, which they want to do also.
well, I'm not sure they want to do that, Your Honor. I haven't heard that. I've said, to what end do you want to use this after doing a quantitative analysis? Well, what are you going to do with it? You're going to do the same thing twice? You expect a different result? I promise you they're not going to do that, because then that would pretty much cause their lab to be.
What if the unknown male DNA is Cousin Eddie's? What's Cousin Eddie going to have to say for himself now? Is he going to march into court now and talk? Eddie, is that your DNA, Eddie? Alex, like, if that shit comes back to Eddie, we ain't using it.
The credibility to be challenged at that lab. They do the same test, get two different results. I mean, we're talking about the same sample, Your Honor. We're not, and they know the mixture. And they tell us the mixture is 99% Maggie Murdoch and 1% unknown male. So, I mean, they've got that information. But we'll do the quantitative analysis. We'll come back and, share that with them. And then, if they, I don't know that, we want to do STR.
But you can't tell me that you can share it with them because you don't know yet, because we don't know how much is there to share.
Right, and so what?
Well, the Othram guy, whatever his name is, might say, you know what? Well, there's not that much DNA here after all, sir. You just made it. We can't help you. We're still trying to figure out that Nancy Guthrie stuff.
What I'm saying is we do the quantitative analysis, then we would know, have an idea of, if we're going to use it all or not. I mean, they didn't use it all when they took their sample, and so there's extract. There will be extract that can be sent back. And Othram will work off the extract that they mix it with a mixture, they put it in their DNA holding devices, and Othram will do the same thing.
All right, let me hear from you, Mr. Waters.
Thank you, Your Honor. This is, first of all, the first time that I've heard that they said they would share. In fact, what I was told expressly was that they would not share anything to start out with. But
Well, I don't think they want to share the results with you,
all right,
okay?
Yeah.
Is what they're saying. However, if they want to do the STR, I think I'd make them share the results with you on the STR. They want to do the SNP for themselves, and they don't have to share it with you under the rules of discovery.
okay. Well, and so first of all, I was informed.
Unless they use it in their case in chief.
Right, and hopefully with sufficient notice. But my understanding is, and I was just texted this, is that they are not accredited in STR. They are accredited in the SNP testing.
Okay.
But to explain what this is, and so it's kind of, there's a bag full, as I understand it, and this was recently explained to me, there's a bag full of, the little fingernail clippings, okay? And they pick out a representative sample and put it in a tube and shake it up, and that's from what's generated. And then you have the remaining portions of that item that are in that bag. And so that's what needs to be processed. So it's not a question of necessarily doing the same thing over. It would be like taking a different cutting from an item of clothing.
Right, you might have a little bit of DNA over here, and then you might have it on the other side of your fingernail, a little bit more.
Correct. And so there is the chance that there could be something that comes out differently. And so SLED can turn around this quant in a couple of weeks. And again, there's nothing to indicate, and this is what I suggested, is that we would do the quantification and the processing and stop. Okay, we're not going to proceed forward with STR on it without calling the defense and letting them interface with their expert. And at that point, we'll know, which is probably likely, that there'll be enough for SLED to do STR or YSTR, and there'll be enough extract for them to do what they want. But their own expert has indicated with the quantification for the leftovers that it's 3 alleles. He's like, that's hardly even a mixture. It's over 99-1. He's like,
That's the leftover.
Right,
stuff.
that's true. But he says there's
Not the unprocessed. They want it all, so maybe they can get something to test.
and I am happy to facilitate that, but we have to have a fair access to that second half as well, and that's what we're offering to do, and to do that with the defense. So again, SLED has the burden of proof. SLED, or the state has the burden of proof.
Well,
SLED has custody.
You can't tell me either that if you prepare the reserve sample, that there's going to be enough for them to do the SNP test.
What I can tell you is that we will do the processing in quant, and that will stop. And that's when we will know, and then we can discuss that. Is there going to be enough just for STR? Is there going to be enough for one? If that's the case, then we can talk about that issue. Or what's more likely is there's enough for column A and enough for column B. But there's going to be no prejudice to that if SLED does the processing in the quant, and that's what I proposed to them, which is fair to both sides. And we will stop and have a conversation with them before proceeding so that there's no prejudice to either side.
Let me.
They've had 5 years Well, and, you know, we were on appeal for a while, but from 21 to 23, they did all the testing they wanted to do. And now we've come up and asked to test it, and guess what? Oh, we want to test it. Well, they've already tested it. And now because we asked to test it, they want to take control of our testing? I mean, that's not fair.
Well, I got it. Let me ask you something. Do you know if you can do an SNP and an STR test from the same sample?
I don't know the
The
answer to that, Your
SNP
Honor.
first and then do the STR?
I personally don't know the answer. We
Do
can
you
find
know,
the
Mr.
answer out.
Waters?
We can find the answer out. But
I'm sorry, Your Honor.
I was just wondering if he did the SNP, the SNP test first, can you take that same sample and do the STR?
As I understand it, we have to process and get to quants, and then we will have an idea of what sort of sample that we have. And then, as I said before, then we can have a discussion with the defense and see, you know, what we have and whether there's enough for this, that, or the other thing. And we can have a discussion, and again, I'm here to be completely fair, and this is a fair process for both sides, and if there's a dispute, then we can come back to Your Honor. But I think SLED, who has custody of this evidence, should do that processing and that quant, at which point we will stop. There will be no prejudice to either side. We'll know what we're dealing with, and we can talk to Dr. Middleman, we can talk to the SLED lab and say, is there enough for column A and enough for column B? And I want to
Let
correct
me
something.
ask you this, are you expecting a different result from your retesting of this sample on the STR?
I'm not expecting a different result, but there's always the chance, just like if there was a different cutting from the same clothing or a different part of the swab. It's always a chance. But that's why with best practices, and I gave you the memo, that reserve sample is kept. And then we're talking about fundamentally burning it all up, and that's fine. It is best practice for a law enforcement agency, particularly with the Preservation of Evidence Act, to keep stuff in reserve. But if we're gonna burn it, then it needs to be burned in a fashion that is fair to both sides. We can rush job this quantum processing. There'll be no prejudice to either side. Stop there, and I'll talk with the defense. And if again, Dr. Middleman already said with the 3 alleles and the leftovers that it's unlikely that he can do anything with that. But we'll have that conversation.
we can do the quant analysis and share it with them, Your Honor. We can do the quant analysis.
Give me just a second. If Althram is accredited to do STR?
He says they're not. I don't know the answer to that.
And Your Honor,
I would accept that they're not, but
Okay.
I need to correct. I think I said they're not accredited in either STR or STP. It's just STR. They're not accredited in, according to what I'm advised.
Okay, that they're not.
Yes, ma'am.
but they are.
You know what they're charging the average citizen to do their own research, and what they're charging law enforcement to do for genealogical trees is completely different, right? And to be real clear, Othram didn't, on the surface, from every single document I've ever reviewed, Othram didn't do anything wrong in the Idaho 4 case, right? The problem when I speak of the IgG use in Idaho 4, I'm telling you, they used it illegally to obtain who the suspect was. Because Othram's only going to be allowed to go into the legal databases, right? That's why they're trying to beef up their database, make it legal, because they can't go to the illegal places. But the FBI could and did, and got the name Brian Koberger. Now, when that exactly happened, and that's still a little bit of the gray area right there. Who actually found Koberger? Was it IgG? Because that can't happen. It has to be something else. That's the problem in the Idaho 4 case. So then when I saw the shade being thrown at Othram and people who did not know the Idaho 4 case, I saw it all unfolding before my very eyes in the chats. And I'm like, oh, Jesus. Thanks a lot, Othram. Last thing Idaho needed was shade because you are now affiliated with websleuths.com. Thanks for that.
And Snow.
Okay.
Well, they couldn't get a sample from Koberger because he was doing everything in the world to hide his own DNA, including putting it in little baggies and throwing it in other people's trash. They pulled trash from Koberger's parents' home, trying to obtain DNA to match the sheath, and they pulled the father's DNA. They didn't know whose it was. It just came back as the potential father to the guy on the sheath.
I was also advised as well that because of the FBI accreditation standards for law enforcement, that SLED has to run the processing first. So it really needs to go, consistent with their accreditation, needs to go from SLED to them. But that's why we're willing to stop and, again, do nothing without any prejudice. But their general rules are it can't go the other way based on the accreditation and the FBI standards.
You have any response to that? He's saying that if I let you go, let Othram do the analysis first, that then their STR won't be accredited. You know anything about that?
I don't know anything about that, Your Honor, but let's step back and look where we are. We're at the defendant. He's asking for this. Who can complain? It's only us, and we can't complain if the court orders SLED to do something that we've asked for. I don't think it jeopardizes SLED's accreditation because in one single case, which they've had.
It's not often that I get the defense asking for DNA. That doesn't happen very often.
Well, there's a lot in this case that you're going to find out doesn't happen very often. But
Ma'am, have you not looked at other crime court cases? A lot of the defense wanted to do their own DNA testing. We got to make sure these labs are on the up and up. Nobody done anything weird in the science lab. They changed their gloves and all the things. All the things.
This is one of them. And so, Your Honor, they do quantitative analysis as part of their accreditation. I mean, it's not like they're doing something that's outside Othram's accreditation. I mean, they are accredited.
Let me ask you, I mean, what harm would it be? Because if I give you the leftovers, they've already done the quantitative analysis on it. Is that right?
Give them the leftover.
CH, I feel you on that, right? Because we in the Nancy Guthrie case was prime example. Why aren't they giving it to the FBI? Quantico. People aren't realizing and didn't want to hear FBI is going to fill it out to a lab from Quantico and then wait on those results to come back to Quantico. We need to get across the board how we're going to handle all of this going forward. Because if I'm a defense attorney in the right mood, I'm going to tear you apart. Right? They need to be careful about all this. It may seem like a bunch of nonsense. Going forward, digital evidence and DNA evidence are huge in criminal cases, right? We better make sure it's all on the up and up and all done accurately and be okay with independent review. You gotta be, if you want to be reputable and believable, right? And you also make another great point. All these different like the cell phone data companies, they're all using different software to pull their information. We saw that unfolding in the Karen Reed trial too.
If I give you the leftovers and let them do the quantitative analysis on that and then hand it over to you, so whatever left over, they did the quantitative analysis, you could give back to them and they can do their STR. What's wrong with that? That way they can keep their accreditation for their STR. I'm just trying, what if he gets a different result? And he wants to use it at trial? And I'm trying to make sure you get your SNAP test. And I'm gonna make sure that you get it.
You know, and from talking to Dr. Middleman, he says
Oh,
to me, what's scientific purpose, or do they want to do this? What's their next step? If there's no next step, then there's a risk when you do quantitative analysis that it will get destroyed. And why take that risk? Now, first time I've ever heard him say, and you talk about we need to communicate, I've emailed him, we've had conversations about this. And
can we get the Othram Guy Lab in here and let's do a little mini Daubert hearing on the side, maybe, to see if he's good enough to bring into court? Daubert hearing, stat.
I've said, what's the scientific basis? What do you plan to do with this once you do this thing and stop? And today, for the first time, he says STR analysis. I've not heard that before. But
I thought I saw it in his motion. Did I not,
Yeah,
Mr. Waters?
And also in an email to Mr. Griffin as well.
well, I overlooked that too, but still.
I can find
And you know what, CH? Othram Labs absolutely went on a little campaign tour with one of the victims' mothers from Idaho. Then another victim's family has a foundation set up now, wanting to, help pay for IgG and cold cases. Guess who's not on their list of labs to use? Othram. But the Florida lab Nanos uses is there. Oh, snap. The hell?
it.
It's not like a piece of paper. I can make a copy of it.
Right.
And it's just such a little amount, and I'm trying to make sure. I want you to have your test.
Well, certainly we can get the leftover extraction pronto. That would get us moving.
And Your Honor, if I could, this is an email to Mr. Griffin, Harpootlian and Barber and associated folks from July 21st, 2026. In which I stated, as we also discussed, I plan for SLED to process the reserve portion of the 70 and 71 samples where we can get quantification, at which point we would stop and consult with the defense on quantifications and the likelihood of remaining extract before proceeding with STR or YSTR. However, as I told you, I've paused that process while we discuss the matter. This is a fair process for both sides and one I'm willing to work with you on, but I should point out Dick made it very clear that the defense would not even promise to turn over results if reserve sample or extract was sent to you. I'm happy to discuss this further and ensure a fair process for both sides.
You would agree with me, Mr. Waters, that he doesn't have to turn it over to you unless he's going to use it in his case in chief.
Well, I will say this, that if we're talking about, that's why we need to process the reserve unprocessed sample. And then we can figure out, and almost certainly there's going to be enough for column A and column B. But I'm willing to do that and stop and then have a conversation with them. And that's what I've offered. That's the fair result. It doesn't prejudice anyone. And of course, the quantification is going to, determine how much material we have. And at that point, the scientists can analyze what is likely and what is reasonable. And I'm willing to involve them in that process. We just got to get to step one, and SLED can turn that around in just a couple weeks. And then I will stop and give them a call, and we'll hash it out. And I'm 100% willing to make sure that there's no prejudice to either the state or the defense.
Your Honor, to respond to that email, we discussed it. You have to understand the context. Before we tried the last case, they indicated there was blood spatter on a t-shirt. We wanted to examine it. We wanted to have it tested. SLED violated every rule known to man and destroyed the t-shirt in the process of processing. Now, it turns out that they also, when they processed it, determined it wasn't human blood. We didn't find that out till very late. But the point is, we want Optum, who is the gold standard, to do the quant piece. They want them to take that piece they've had for 5 years. Did they check it to make sure the first one was right 5 years ago? No. Now, when we have Optum, oh, we better check that, so make sure we didn't screw this up. This is just a CYA. This has nothing to do with seeking justice. So I would say, let us have the unknown sample, had been processed, let Optum quantify it, let them, and if it's not going to result in them losing their certification, don't test it. They've taken 5 years and not tested it. Why should we run the risk of them screwing that up? That if we screw up the quantification, we accept that. If they screw it up, we don't have a sample.
I understand.
And that's why I'm so passionate about it, because we went out there to SLED. We dressed all in, Mr. Waters with us, had on lab coats and went in there and examined the thing and took pictures, and then, you know, we couldn't test it. I don't have any faith they won't screw this up. But whether you have faith in them or not, why don't we have an independent right to examine the untested DNA? Why don't we have that?
Your Honor,
Except there's some procedural issue about their certification. We have a right to a fair trial. We want to.
Yeah, you have somebody from SLED here that can tell me about, if I give them this sample, you can't do an STR?
we do have Lieutenant Stanley from SLED.
Come up here and speak with me, but I'm gonna put you under oath. Madam Clerk.
You someone will swear or affirm that the testimony you give the court is the truth, the whole truth, and nothing but the truth, so help you God. I do.
Okay. All right, well, tell me how you lose your accreditation if I give them a sample and then you take the leftovers and, yeah, you can go right there at the podium. And you can't produce an STR that could be admissible in court. Is that what you're telling me?
Good morning, Your Honor. I am the quality manager for the laboratory, so my job is our accreditation and making sure that we are complying with accreditation standards. The DNA laboratory is accredited by the same entity as Othram, but in different capacities. We also follow the FBI Quality Assurance Standards, or FBI QAS standards, that are put out by the FBI for DNA caseworking or testing laboratories, as well as DNA databasing laboratories. In order for us to accept data from, or accept a sample from another laboratory, they need to be accredited in the same services for us to continue our testing. So it's not necessarily losing accreditation, because we just wouldn't be able to accept it and perform the testing.
Well, let me ask you this. What if you got a sample and it was the only sample you had that had already been processed? Just hypothetically, are you going to tell me that you're not going to do an STR on it and try to admit it into court?
We may not be able to, is what I would like to tell you. We share samples with Othram, for example, or third-party laboratories, but we're typically giving them the extract or the remaining portion, and they're able to work with that for their samples. We are unfortunately not able to work with theirs.
Why?
I'm not as familiar with the SNP testing, so that might, my understanding of that is it has to do with the standards that are followed for the accredited laboratories.
Okay. All right, thank you. Mr. Griffin, let me ask you this. If I give you the leftovers and I give you the unprocessed sample, you have it quantitative and you do your SNP test, and then you give them the leftovers.
CH, she's the quality manager at the SLED lab. The lady that was just testifying and sworn in.
And they can do their STR test would you consent to it being admitted into court?
Yes, Your Honor. We wouldn't raise any objection as to the
To accreditation or
accreditation, chain
anything
of
like
custody,
that?
thing like that. Now, if there's some other irregularity in the process, sure, but not because of it flowed from Othram back to SLED. No, we would not object to that.
Okay. Anything else from the state?
Your Honor, just as to that last hypothetical that Your Honor stated, I think that the same thing would have to happen, that after processing, you have to stop, because only then are you going to know whether there will be leftovers. And that's the whole, what I'm proposing is we process and we stop. And at that point, we'll know whether there's going to be enough for STR on SLED and enough for them to have the leftovers of that. And that's exactly what I'm saying. But if they go ahead and run the SNP without consulting with us, there may not be any leftovers, is what I'm saying.
Well, let's talk about that, because why even get it processed if we're going to stop? Then what's going to happen?
So we'll know at the quantification point, we'll have an idea at that point that if we proceed with STR testing, whether there will be, like there was in the other examples, 47 or however many microliters of extract remaining for then to be provided to Othram, which again, the original leftovers were willing to provide. But the processing in the quant is where we kind of know what we have and what, if we do further with it, do actual testing with it, what is the consumption possibility at that point. And so that's why I'm proposing that we process it, we'll know what we have, and then we can actually have a discussion of who can do what with what. And that's what I'm proposing to do, and have SLED do that. We can turn around in a couple
Well,
weeks.
this is their motion to do their SNP test.
Sure.
And that's what I intend to rule on today. Not get halfway through it and come back and hash this all over again.
I absolutely, Your Honor. But once we get that quant, then we will, and their expert will know exactly, first of all, is SNP viable, and secondly, the amount of consumption that will be necessary for that. And so that's why we're not kind of like stopping. We're just, I don't know.
What is your position if the SNP test destroys the whole sample? There's nothing left.
So, Your Honor, what we want to do, we want it all to go to Othram. The unprocessed, they will process it, they'll do a quantitative analysis, and we'll share that quantitative analysis with SLED. And then we'll know whether there's enough to do both. If there's not enough to do both, they'll know that, we'll know that. But and we want to do the SNP testing with that. We may have to be back here and having the same back and forth. But what we don't want is SLED to keep it, SLED to do a quantitative analysis, and then say there's not enough for you to use. I mean, that's what we don't want.
That's my whole offer, is I wouldn't proceed without having that discussion and with them. So that's the whole point of what I've made, is that we'll know what we have at that point. I'm not going to do anything to prejudice anybody, but we got to process it to know exactly what we have and what we can do with it.
And we want to process it.
I understand. Mr. Griffin, I'm gonna grant your motion. I'm gonna let you, take it. The leftovers, the new, y'all make sure you make a chain of custody. I'm gonna let you, have the analysis done quantitative, then I want you to report back to the court and tell me if there's leftovers before you do your SNP test. I want to know beforehand, and then, because I've got to get this started. I I've got, you need 90 days at least. So we need to get it started. I want you to report to the court, let me know, and then I'll have a discussion with y'all on what we're going to do.
All right, thank you, Your Honor.
Okay?
Thank you, Your Honor.
Thank you. All right. Just gonna hold up and let me know. All right, let's talk about transfer of venue. Who's,
Your Honor, before you do that, we have a 5-minute recess.
I wish they'd just leave Othram out of it. The waters have gotten so muddy because of Trisha's stupid involvement or their dumb involvement with her, right? Give it to a different lab at this point. Othram's just like, yes, please call me. We want all the publicity. That's what our sole goal was from the beginning. The guy's like, he thinks he's some kind of PR magnet. I'm going to run out and do all these things. And he's hurt himself in the process. I still don't know people understand what Othram does. And CH is right. They cannot do the S&P at the state labs. They do STR for CODIS matches. This what the act. Send it to CC Moore. She's going to do the same thing Othram's going to attempt to do. Same thing. She describes it beautifully over and over and over and over, all over YouTube. The process may need to be questioned and Othram may need to be questioned, but the process is going to be the same no matter what lab it goes to, right?
I'm sorry, I have a bad habit of keeping right on going. Absolutely we can. Court's gonna be at recess for, let's say, 15 minutes, so I can give everybody else out there a break too. All restrooms are located on each floor in the same place over to the right. Okay, thank you.
In case y'all need one of them comfort breaks. They might need to get one of them comfort breaks in. Okay, let me see. Hang on, I was researching something. Let me pull up my chat where I can see what's happening. We're a couple minutes behind there, but I don't know how much behind them we actually were, guys. Okay. No, the defense deserves to get their DNA testing in. I have no problem with it whatsoever. This channel here will never be 1,000% pro prosecution nor defense or law enforcement. I'm questioning everything, especially those that are trying to force me into a narrative. Like, what? Hold up a second. Give me breathing room. Because I'm not going to sit here and go all in on either side. I think they do deserve all their testing. I have no problem with it. If it's exculpatory in the end, then it is what it is. I'm not trying to manufacture evidence over here. And I don't want them to either. So I let them have all the testing they need. I don't like it when defense attorneys are blocked because is that fair? Right? It's happened in Lindsay Clancy. Her attorney got blocked from bringing real women in to discuss their real life experiences instead of hearing all these armchair people who think they know stuff. And I have to keep reminding them all, you know what you know based on what doctors have told you, correct? And what you've heard over the years about these disorders. Am I correct? Yeah, that's what I thought. I agree, CH. Hang on, I'll get this back. In a world where he could have hired somebody. Absolutely. He's not above hiring the people, is he? We know that. And in the end, if Murdaugh didn't pull the trigger, he facilitated every bit of it. Oh, I'm not. I take it all with a grain of salt, CH. I listened to. No, they're back in the courtroom. They're just standing there. See, I fast forwarded it. They were back in, but we're talking. So I just backed it up a little bit so I could see when they actually start. But it is unmuted. It was for a second, well, because I was trying to talk. But I just got it up right now as I'm trying to respond to my chat. But yeah, I always side eye at CH because if you gotta, the process has to be on the up and up in the lab, right? I'm gonna question that lab process. I'm not gonna go blind and just believe it. I want to know too. And Ann Taylor received so much information on that genetic genealogical tree they were putting together that no other attorney has ever gotten before, y'all, because it's the first active case. She literally had to go to court and say, I want this from the FBI. The judge said, are you willing to file your TURI request? She said, yes, sir. He said, do it and I'll give you the subpoena. And she did it and she got it. That was huge. The judge had to spend 3 days on a private in-camera review of all that material, unpack it and figure out what was happening here. And we're just now starting to get some of those documents. We'll never get that IgG tree from the FBI. Never. Yeah, I don't like the misinformation, Elizabeth, right? We can discuss the weeds, we can discuss alt theories, and we are, with the understanding that's what we're doing. But we're always going to go back to the facts and base it on the facts. And the internet won't tell me how I'm supposed to think because someone looks suspicious or the whole thing. I'm not going to say, I don't want to live in a world where I wake up every single day and question everything I see and hear on the internet. And what I see in court, fake videos, fake all that. Are y'all really, y'all gonna put up with it and just run amok and talk about it's happening before our eyes? Demand they stop it. Are we afraid to stand up and demand things in this country anymore? Because we might get told to sit down and be quiet? You're not being a critical thinker if you're not looking in the weeds and wearing your tinfoil hat today. Well, you may not be accepting actual evidence because you won't take off your tinfoil hat, right? Hell, we see it in the Lindsay Clancy case. TikTok is running amok and wreaking havoc on all these simple-minded little people out there who now think Patrick Clancy killed his kids. Hell, I saw this morning people are putting a video out there. If you watch closely, Lindsay's mouthing the words in court, he did it. What? Fucking weirdos. I'm sorry. Right, CH. It's not really what the lab is doing to develop the result or the profile. It's what we're doing with that profile. And how accurate is this? And now you got websleuths.com encouraging people to come be armchair detectives and help us search for relatives. Like, what if y'all are making mistakes along the way? Can we see your worked product? Can we review your worked product, right? Right now, court's coming back in session, guys. And when they start talking, I'll shut up. I'll mute. But until then.
Thank you, Your Honor.
You're welcome.
I remind you of my age.
And how old is that now, Mr. Hartbilling?
Really? On the record?
On the record, Poot, 110. I'm being a little asshole. He's not that old. Don't know how old he is. I don't think about it. Don't care.
I'm old, okay?
You're not under oath. You're not under oath.
It's okay if you lie. You're not under oath. We all are human. We all live in the flesh from time to time. Boy, don't we?
All right, do I have everybody? Okay. Mr. Waters, you got everybody at your table?
Yes, ma'am, I do.
All right, then let's proceed
Everybody here? Did y'all all come back? No one took a nap?
with the defense's motion to transfer venue, please.
Your Honor, let me, at the outset, you know, we've attempted to try to negotiate something with Mr. Waters, which has not been successful. But the only person in this courtroom that has a constitutional Sixth Amendment right to a fair trial is sitting right there. Now, the state has some due process concerns. If we wanted to try it somewhere that was totally, for instance, inaccessible, we wanted to go to Oconee County.
I'm gonna be there next week.
Well, hopefully you'll get back.
Oh, damn. What's going on in that county? Why are you hopeful the judge will get back? Oh, goodness. She better take security with her.
But, you know, we understand that. But they don't have, beyond that due process right, any pick, if you will. They're not entitled to the venire they would like to have. The venire we have to have is the venire that's the fairest to him. The venire we have to have is the one that's more likely to either have not formed an opinion, or if they have formed an opinion, it's such that they could disregard it and base their verdict on what you tell them and what comes out of that witness stand. I mean, that's black letter constitutional law for the last 200 years. Now, this is a complicated situation because the media coverage of this has been,
Oh, shabugs, they're just good old boys, never meaning no harm. Beats all you ever saw, been in trouble with the law since the day they was born. Right, Alex? He's like, yeehaw.
in my experience, unprecedented for a number of reasons that go beyond just the fact of the notoriety of the case. I tried a death penalty case in Newberry County 25 years ago, covered gavel to gavel by Court TV, watched all over the country. There was no social media, there was no internet, there was no, we actually had newspapers where people got their news. And
Social media wasn't invented then.
wasn't
He's a lesson on newspapers. God dang. Y'all, this is really a good relief from the heaviness of the Clancy trial we've had to endure. So I'm going to enjoy every minute of this shit.
even invented yet. We had three networks, three television stations. And it got some notoriety. It was a pretty famous case. The son of the Episcopal bishop of the state was charged with murdering his wife, who was the daughter of a state senator. Got a lot of coverage. And Henry Floyd heard the case and had a jury from Oconee County seated. We didn't even have because of everybody in the county knew one or the other. So I've been through this process before, but the most notice it got was I get a call from somebody from Arizona who watched it, and when I got back to the office telling me what I'd screwed up that day. But nothing like what we have seen in this case. Wall-to-wall coverage, internationally, nationally, and the state, when you start talking about, and they talk about media markets, it's irrelevant. Whether you were in Greenville or Charleston or Beaufort, it didn't matter. It permeated everybody's consciousness. 10 million people watched this, and if they didn't watch it live, they watched it on YouTube or Court TV that night, or with the feed on their phones. I mean, it just permeated everything. So what's the solution? Well, first of all, I don't believe the state is arguing we should go to the 14th Circuit and try to pick a jury. And we have enclosed a copy of an order issued by Judge Kelly, I think yesterday or the day before yesterday, in a civil case where the defendants in that case, with a lot more resources than us, developed all kinds of factual bases as to why that case, which is related to the boat death case, the Parker case, should not be tried in the 14th Circuit, and he moved it to Spartanburg. And we would ask the court to allow us to introduce all the exhibits relied on by Judge Kelly in that matter into this matter, so that Your Honor will have the ability to review all those. We'll get them and get them to you if necessary. There are statistical studies. Judge Kelly's order is a work of art.
I read it yesterday.
And like you, I think you probably would agree with me. Well-reasoned, factual basis is extraordinary, and that's a civil case. where,
Right.
you know, there is no Sixth Amendment right on either side. So I would say, and I don't believe anybody's going to seriously argue that we go to Carleton County or even Beaufort County and try to pick a jury and waste our time down there.
Waste our time in Beaufort County. Nothing ever come good of the Beauforts in the South. Ever. Ever. What? Oh, hell,
In June of 2022,
hold on, I'll fix it.
he was indicted by the state grand.
I hit the wrong button. I'll fix it. Hang on. Let me get where I can get this larger. Uh-oh. Hang on. Let me mute myself.
So there's no, I mean, do we have the money to have some sort of poll or do what they did in the Parker case? No.
Time. I want to get somewhere where we can get 12 in a box and get a process that
He said he wants to get somewhere we can get 12 in a box. What?
win, lose, or draw is going to be one that sticks, and that's the state's goal.
Okay, all right.
Based on his filings and our discussions, I'd assumed that we were going to leave the 14th Circuit. First of all, if you want me to walk through the rationale Judge Kelly had in his order he issued yesterday, I'll be happy to do that. But I think our filings make it very clear.
I've read your motion, I read your memorandum in support, and then I read the state's response. Then I read your response again that you filed with the court. I've read it all. But if you would put your position on the record for me.
Okay, well, the 14th Circuit, which is Carleton, Jasper, Beaufort, and Allendale, is where the defendant is from, where his law firm has operated for 100 years. The Murdaugh name is well known throughout that entire circuit. And so that circuit, the movies that were filmed, the 5 movies that were filmed in Carleton, Jasper, and Beaufort. The Murdaugh case is a local freak show. You have people being interviewed on the street in all those counties.
Kind of like Letcher County, Kentucky. Oh.
Commenting on whether they thought he was guilty or not, or whether this happened or that happened. I mean, it was so outrageous that Buster Murdaugh is suing Netflix for accusing him of murder.
He sure is.
That's a civil case that's going on in Hampton County. So there's no, I mean, do we have the money to have some sort of poll or do what they did in the Parker case? No. And that's why I want to rely on what they found in terms of their ability, Parker's ability, to get a fair trial in this community that's permeated with this pretrial publicity, the movies, the books, 6 books on this, and many written, a couple of them written by folks down there other than the clerk. So,
And I also read in your motion, Mr. Harpooling, that there were fewer than, correct me if I'm wrong, fewer than 1 in 7 prospective jurors were qualified to serve. That was during the first trial.
Correct. Before the conviction, before the movies.
Exactly.
Before the books.
And before Becky Hill.
Before Becky Hill.
Which is something totally different, but also very prejudicial to the defendant, would you not say?
Your Honor, I concur completely. And so Carleton County is poison. I don't think he, with a straight face, the state would argue that we should go back to Carleton County. The courthouse, no offense to my friend the clerk over here, but the courthouse is the scene of the crime. We can't go back there. So once you get that out, Allendale and Jasper.
The courthouse is the scene of the crime, like Letcher County, Kentucky.
Are smaller than Carleton County. In 1 out of 7, if that, and I think that's probably what's going to happen in that entire circuit. In Beaufort, Beaufort is a county where their firm operated. He's well known, and he's a local guy, and so he's vilified. He's convicted of murdering his wife and child. It's horrendous. Stealing $12 million. Horrendous. And so, but he's entitled to a jury that can put all that aside and base their verdict on what you tell them and what the witnesses say. And that ain't gonna happen in the 14th Circuit. That ain't gonna happen, definitely ain't gonna happen in Carleton County. And it would be an exercise in futility to go down there, set up all the infrastructure, and try to pick a jury. We, after 3 or 4 weeks of not being able to get a jury, or people, most normal people would run like a scalded dog from this case, because it could be 3 weeks taken away from their, we're not moving for sequestration, taken, at this point anyway, taken away from their family and their jobs. No rational person wants on this jury. And that's going to be tough, especially in that community. And now I'm not telling you that we go to, and we say Charleston, that there won't be a huge number of people who know about it and have made up their minds. But if you have a
Well,
potential,
that's due to all the publicity.
due to all the publicity, it's just that we're going to have a huge. We went through 400 jurors in the Gaskins case, 400 before we could get 12, and it took 4 weeks. And so I've watched this process, and if Your Honor's voir dire is as incisive as I believe it will be, folks will come off the, well, yeah, I think he's guilty, but, I could give him a fair trial. Or, I know all about the case. I watched all the movies. I've read all the books. But I can put that aside. I mean, that just doesn't, somebody like that should not be allowed on the jury. And
I beg to differ, but I understand what you mean. People they come in with biases that can't be helped. But because of the times that we do live in, and we do have social media is now invented, pretrial publicity is going to always be an issue. How do we handle it going forward? Set standards today, so we don't have to spend hours in court going over why we can't have a trial here in our county, right? Jury corruption, jury biases, all the things. Pretrial publicity is a thing. They got to get used to it and figure out ways to handle it better.
We're going to see many, many, many more of those than we saw in Carleton County 5 years ago. Now, their counter is Charleston's too expensive. There's no evidence in that record that you can't get accommodations within 15 minutes of the courthouse that are the same as you pay in Gaffney. That's number one. Number two,
Now the hotels are too expensive down there in Charleston.
the convenience to getting there, it's 15 minutes. Number three, he says, well, we don't know we're going to have parking allocated by the clerk down there or by the court. This morning, Mr. Waters and I drove into, we had 2 reserved, I think he may have had more, 2 reserved parking places right out in front of the courthouse. It happens. That's what happens. So, yes, they can accommodate the parking, the drive, cheap hotels. He's asking, and by the way, if it did cost a little bit more, let's say it did, he has a right to at least have access to jurors who haven't made up their mind, who have read about it perhaps, and could honestly say to you, I haven't made up my mind. I'll listen to you and the witnesses and follow the charge. And that's the acid test. Not whether you're going to have to pay $20 a night more a night there than you would in Newberry, where the solicitor there is going to be prosecuting the case, or Lawrence. And of course, we would say to you, we need a big county, not a small county. We need a big county. So you're basically limited to Greenville, Columbia, and Charleston in terms of the jury pool. Greenville, for all the witnesses, every witness would have to spend the night. Carleton is 45 minutes, Walterboro's 45 minutes away from Charleston. Witnesses can drive over at 2:30 in the afternoon, testify, and drive home. So the cost of putting witnesses up is gone. If you have an expert witness coming in, very easy to get them into. Of course, we had the problem in Walterboro, no airport. They had to fly into Charleston, drive down, fly into Savannah, drive up. So you need someplace that has good access to airports, because we are going to have several out-of-state experts. I'm not sure what experts they're going to use, So Greenville logistically doesn't work. And by the way, if you're going to stay at a Days Inn in Greenville, they're charging the same price in Mount Pleasant. Same price. And of course, if you are looking for a jury pool where you can find those 12 or 14, however many alternates you're going to have, the bigger the panel, the easier that will be. If you use that 7%, let's say it's 5%, if you summons 1,000 jurors, which you could do in Greenville or Charleston or Columbia, and 5% are qualified, that's 50. We can get a jury out of 50 people. But you go to one of these small counties, you can't get I bet you can't get 1,000 jurors to show up. It's been my experience in the rural counties are a little less willing to come in, and they don't want to be gone for 3 weeks or 2 weeks from their jobs. And it's going to be tough. Getting a jury in this case is going to be extraordinarily difficult. Why make it more difficult by limiting your choices? Why make it more difficult? Because, and again, there's no tactical advantage to us in Charleston. He's not from Charleston. I'm not from Charleston. The Charleston is going to give us a larger jury pool that's more accessible to 30 or 40 witnesses in this case from Carleton County. So when you look at the cases on this issue, they all come back, and I understand they have a right to a fair trial too, but he has a Sixth Amendment right to a fair trial. And that Sixth Amendment right means, and let me say this to you, you know what else you get with Charleston? No appeal. I'm putting on the record, if you give us Charleston, we will not appeal the venue issue, ever. Take that one off the plate. Not that
You're requesting the change of venue.
I know.
Just want to make sure that I've got that right.
If you deny the motion for change of venue, we're going back to Carleton. So I don't really think, and correct me if I'm wrong, that is a viable alternative. I think we've got to move it somewhere. And we're suggesting Charleston because we think that will be the most expeditious way to get a jury that truly has not made up their mind.
Okay.
Now, he's arguing cost. I heard him. He's trying to get Mr. Barber to say Charleston is expensive. And when I'm there, not on business, well, sometimes on business too, I stay at really nice hotels and eat in really nice restaurants. But we won't be for this. He's broke. He hadn't had a job in 4 years. And if he did have a job, the feds or the state would be seizing the money. So, and and let me say this, we have an office in Charleston within walking distance of the courthouse. So that makes it more economical for us and allows us to have the money to hire a DNA laboratory in Texas. And we're going to have to hire other experts from outside the state. And we want to put our money into that, not having to stay somewhere else or even paying for witnesses to have to come somewhere else. Now, our memo talks about, all kinds of things and the factors. But Your Honor, first of all, I would say to you, if he gets up here and argues we need to go back to Carleton County, then he is, and I don't know why he would do that. I have no idea why he wants to go back to Carleton County. Maybe it's his lucky courthouse. But it's not rational and compared to what his Sixth Amendment rights are.
Okay.
Happy to answer any questions you have.
Thank you. All right, well, let's hear from you, Mr. Waters.
I apologize.
Your Honor, I want to start out by saying, and the state was in a leadership position prior to the first trial in putting together logistics, doing things like asking for a gag order in order to try to do exactly what the state wants, and that is to put 12 in the box who honestly can be fair and impartial to both sides. That's been our entire goal the entire time. This is as I wrote in my motion, this is the world we live in, and the genie is out of the bottle. And I'm not going to sit here and not say that this case has been unique. almost nationwide in the amount of publicity that has been generated. And so that is going to be something that's going to be overcome. But the law is very clear that the remedy for that is, of course, an effective voir dire process. And we put together a good procedure last time. It was very efficient. It worked, even though the frenzy was out there then too. I want to be clear that I'm here to be reasonable because as I said before, I want to pick a jury that win, lose, or draw will stick, and that we have a fair to both sides. And I believe that we can do that. But the issue, of course, is not pretrial publicity. Long gone are the days where people got their news from the evening paper or the morning paper, and it is ubiquitous out there. So we're going to have to rely on our citizens and identify those citizens who can put whatever they may have heard aside and honor their oath to be fair and impartial. I also want to be reasonable here when I say that I'm happy to consider any other option, but I also am a steward of the taxpayer money. And the statute also requires the least logistical expense. I also, as I said before, we didn't let court break down for 6 weeks, and it was a logistical, huge effort that I give credit to a lot of these staff members back here and keeping one witness coming up after another to get this thing going. And so I'm thinking about those things, and I have been in court. I love Charleston. Charleston is one of my favorite places in the world. I have been to court down there many a time, and it is always a logistical difficulty. And to contend it's not the most expensive city in the state, I don't know what to say to that. So I have to at least not be, when the defense says Charleston or nothing, I have to at least say, Your Honor, there's problems with that, and we believe that there are other choices in the state that would be better, of which I am happy to talk about and consider those other choices. That's been the state's position. In the end, Your Honor, all I want is a fair jury to the state and to the defense, and have us be able to present our case to citizens who are going to abide by their oath and be fair and impartial to both sides. And that's the process that we're looking to have happen.
Okay, thank you. Anything else from the state? Defense. I'm sorry.
I have so much to say, but probably not. Thank you, Your Honor.
Thank you, Mr. Harpillion. All right. I understand. It sounds to me like y'all are just agreeing to disagree. Y'all just want, each one of y'all want a different place to hold it. But let me tell you, I read your motions, and I took them seriously and went through and did some work on them. And I'm going to tell you, after reviewing the motions submitted by both sides, I even went back and looked at the transcript of the jury selection that was conducted back in January of 2023, and also the opinion from our Supreme Court. I'm going to order that venue be transferred to a county outside of the 14th Judicial Circuit, because I believe that the defendant cannot receive a fair and impartial trial in Colleton County. I'm making this ruling in pursuant to the South Carolina Code 172180, and it's supported by case law. That would be State v. Law, where the circuit court retains the power to transfer venue outside of the circuit where a fair and impartial trial cannot be had. So I'm transferring it not only from Colleton County, but out of Colleton County completely. I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. That can be cured. But with the 4 grounds that I've just stated, I am transferring it. Further, this ruling is supported by the court's recent order in Beach v. Parker that I just read yesterday that Judge Kelly, I was interested in his order. I did go read it. There, the court found that the moving party made an affirmative showing that a fair and impartial trial could not be had in Hampton County due to the extraordinary pretrial publicity and the surrounding litigation. The court concluded, other than publicity, the settlement of the wrongful death action, the criminal prosecution of Mr. Murdaugh, the defendant in this case, including his reversal by the clerk of court. The same publicity and public attention that justified transfer in Beach is present here and further supports this court's determination of a change of venue is necessary to protect the defendant's constitutional rights. Further, I'm going to find that under Section 172185 is not an adequate alternative. That procedure would require Colleton County to bear the substantial cost of transporting, housing, feeding, and securing an out-of-county jury throughout a multi-week trial. More importantly, it would not remedy the prejudice identified by this court or eliminate the concerns arising from retrying this case in the same community where the constitutional violation occurred. I find that there's no lesser remedy that will adequately protect the defendant's constitutional right to a fair and impartial jury. The court rules venue is transferred outside of the 14th Circuit. I'm going to reserve my ruling to the specific county in which this matter will be transferred. Let me tell y'all, it takes a village to get this case transferred. For those of you who don't know, there's a lot of other things besides walking into a courthouse and sitting down and trying to try a case. We have to consider security, transportation. Is a courthouse adequate? Is there lodging? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider. So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case. Colleton County is not a rich county. It's a poor county. So that will be at the foremost of my thoughts when I transfer this case. I was in hopes that the two of y'all could agree on a destination, but since that's not happening, I will decide and I will let y'all know. I will issue an order. I will do a formal order on my transfer of venue and also will designate the county into which we are going to try this case. Okay? Any objections?
None from the state, Your Honor.
Perfect.
Thank you, Your Honor.
You're welcome. All right. Now, the last motion, Mr. McCullough, I know you've been sitting here since 10 o'clock. If you could come up and just for the record, state your position. I believe I've got, Mr. Waters, I believe I have your stance on this, but I'll get you to put it on the record and let me rule, please. Go ahead, Mr. McCullough.
Your Honor, the benches are hard and life is short, but I wouldn't have missed the Charleston travel log for anything.
I wish I would have. Go ahead.
Your Honor, I don't want to detail I'm here representing Myra Crosby, a former deposed jury in the criminal trial, which you're obviously familiar with. And given your nature of preparation, I know you've read my initial filings. If you have any qualms about how this matter comes before you, I will streamline that by simply saying that following the plea of Ms. Hill in December of 2025, during that proceeding, Solicitor Hubbard, who was placed in charge of the investigation for jury tampering, indicated the case was closed, no charges would be filed. From that point, shortly, several months after that, in March and then again in May, we filed freedom of information requests for the jury tampering investigations, which were closed and therefore no longer susceptible to any exception under the Freedom of Information Act. And we sent that to SLED, the Attorney General's office, and to Mr. Hubbard's office, Solicitor Hubbard's office. In response to that motion, I think it is correct, and I don't want to preempt, but Mr. Waters is here. General.
Sorry to interrupt. Thank you, Happy, because I was just thinking the same thing. She's special appointed judge, right? So would she stay with it? We saw this in the Delphi case with Judge Gall. So I'm hoping that is the case. CH, I was right there with you. We're going to change venue. Yeah, we agree, but we like this judge. So Happy, thanks for bringing that into the conversation as well. I hope that she does get to stay with the case.
Counsel for SLED is here, and I spoke to Solicitor Hubbard outside to just confirm their positions are not in opposition to the remedial attention to the protective order, but they do say that they all three, as agencies, are constrained by protective order, which includes at least, if not is, the protective order of Justice Toll from January of 2024, issued preceding her new trial motion hearing. At that time, she issued a protective order, which I think the primary concern was to protect the identity of the jurors in the case that may have been to some extent interviewed in whatever jury tampering investigation led up to that point, January 24. And of course, that investigation continued after that hearing, after January 24. So we're simply asking, and there was no other way to get here, Your Honor. We originally filed a motion to intervene, to have a court review the protective order to determine that those issues were now moot, and at least the issues that Justice Toll addressed, or the reason, as I read her protective order, for constraining any release of investigative materials relative to jury tampering. Now, there's been a little confusion. The in-camera proceedings, I am not seeking the release of, because I have that, but I am constrained by the order of Judge Newman. I was allowed to have them, but I can't disseminate them. I'm good with that, and I don't think those aren't the issue today. So I wanted to eliminate that confusion. I'm here today simply asking, Your Honor, pursuant to the Freedom of Information and you know, the purpose of the FOI is to simply make it possible for citizens and their representatives to learn and review the activities of their government. And secondarily, Ms. Crosby asked me to pursue this because she wants to see the quality of the investigation. She wants to evaluate it. She believes the public should be able to evaluate it. She is hopeful that it will lead to additional information in support of her belief that she was targeted through an orchestrated effort to remove her from the jury. So for all those reasons, Your Honor, I believe that it's appropriate for me to be before you as the assigned judge for all things Murdoch and to ask you to review that protective order and any others that could be referenced that I'm not aware of, and to conclude.
You're not asking for any jurors' names or any
I'm
kind
not,
of
Your Honor,
identity?
but that's the worst secret on the planet. I think that half of the jurors went to New York and appeared on the Today Show, I think.
Well, I understand all that, but
I'm
you understand
not
as a
opposed to the
court,
redactions.
as a court, you know, we protect our jurors. Now, whether they want to get out and go dance on ABC and tell them everybody who they are, that's fine.
Your Honor,
But I'm not comfortable in unsealing any identifying factors for a juror or a juror's name.
not asking for that, Your Honor. And
Okay, just wanted to make sure.
I respect the position of the Attorney General's office, which actually filed the only responsive pleading. So I respect that. My only concern is simply this. When you begin redactions, I do not want to have to be back here or through the Freedom of Information and a lawsuit complaining about Epstein proportionate redactions. Protecting
Okay.
the identity is one thing, but I don't want to get pages and pages of blacked out, redacted.
I understand.
So that's our position.
Okay, Mr. Waters?
Thank you, Your Honor. First of all, as we detail in our response, there were multiple protective orders during the course of this. And
Right.
of course, the first thing we have to talk about is what you just recognized, is that the court promised those jurors over and over again, both Judge Newman and Justice Toll, we're not going to release your identity. And we deal with this all the time. Just because I might be subject to state grand jury secrecy doesn't mean somebody who's subpoenaed can't go run their mouth about it. And I still can't run my mouth about it, right? Except as necessary in court. So, and so the other thing is that we also wanted to protect, of course, ongoing investigations, which have resolved at this point. And so that's why we have filed a motion to unseal. However, our motion to unseal also includes the sealed portion of the initial inquiry that got that juror kicked off the jury. Okay, and that's important that that come out. In fact, I find it interesting how Mr. McCullough says he wants the public to judge what happened, but he doesn't want them to see what was the basis for the exclusion in the first place. And so there is that needs to be unsealed at this point now. There's no reason to do that. Of course, redacting identities, and that, of course, is the only limitation that we have, is that those juror identities be redacted. The main difficulty in that is there are some MOIs. Those are easily redacted, and other personal identifying information that are normally redacted to protect people's privacy. The MOIs are going to be easy to do that, memorandums of interview, but they are summary documents only, and there are of course body cams of interviews and that sort of thing, and so that's going to be a little bit more difficult and it's going to take some time to do, but subject only to that, to honor the court and frankly the state's promise that we won't be the ones to release your identities. We believe that not only should the sealed inquiry at trial be released, but also within the appropriate bounds of FOIA and subject to redaction, the investigative file as well.
Okay.
No, I would only respond by saying that with regard to the in-camera proceedings, we're not asking for that to be unsealed. I find it fascinating that the Attorney General's office is. I don't know how you're going to redact the identity of the person that everybody in the universe knows was the object of the in-camera proceedings and the only person who was removed from the jury. But I certainly will respect your ruling.
Well, if someone else decided to run their mouth and go to the media, then that's on them and ain't on us. I would also point out, Your Honor, that Mr. McCullough on June 24th, June of 2024, requested unsealing of the in-camera proceedings, and then filed on September 4th, 2024, a petition to intervene with the Supreme Court to seek it unsealed. So on multiple occasions, he has requested to have it unsealed. So,
And I achieved my goal, which was to have access.
I like for everybody to know everything. So this is the deal. We're going to unseal it. We're going to protect the jurors' names. I want that redacted. I want any identifying information concerning a juror redacted. Unseal the rest of it.
That's exactly what the state wants. Thank you, Judge.
Thank you.
We don't like those sealed documents neither, ma'am. We want them all unsealed. Could you speak to the people in Idaho? Asking for a bunch of friends.
All right, now with all that done, let's talk about when we shall meet again. Already, yes. I'm telling you, I'm keeping us on schedule. We're going to get this done. My 2 dates for my next hearing. And let me just tell the lawyers this. I did have a motion to exclude evidence. And the state's motion to admit evidence of motive. And that's going to involve the financial transactions. I think a ruling at this time would be way too premature. I want to be closer to trial. I probably will not even consider those motions until the beginning of next year when we start doing pre-trials. However, Mr. Harpootlian, your motion to dismiss, I was told I would be getting a supporting memorandum, which I do not have. I pushed that out because the state hasn't been able to respond to it, because they haven't been afforded the opportunity. They don't have it. I will push that out to the next pretrial hearing. I do not want the DNA, Mr. Griffin, to wait that long, because I'm thinking either November the 13th or November the 20th. That would be here in Lexington, again at 10 o'clock. That way I can address any other matters that might come up. Any of those, do those dates work for y'all? I know it's close to Thanksgiving, but I was trying to get it in so I won't bother you over Christmas, because I'm going to start bothering y'all again in January.
The 13th would be far preferable to us, because so I can have all my staff available and everything for that.
Okay. How about you, Mr. Harpootlian?
What was the first date, Your Honor?
The 13th, November.
November, well, okay, let me look. It's wrong month. Friday, it's a Friday.
The 13th?
Yep. Friday.
Oh, gosh, is it really Friday?
That's
Well, I
perfect,
didn't
Your
mean to
Honor.
do that.
That's perfect, actually.
The way things gone, that's our lucky day. That'll be fine.
Okay. Oh, that's too funny. I'm sorry. I just did not realize that was Friday the 13th, but I'm not superstitious. I hope you're not. All right, November the 13th, 10 a.m. is going to be our next pretrial. We will take up your motion to dismiss. Please have your memorandum filed timely. Let me say timely, because I was working the weekend. I get 18 motions at 5:15 on the 7th. That was fine. Then I've been getting motions all week long, and that's fine too. I understand y'all are busy and you have stuff to do, and but please try to be timely. So I'm going to tell you before you say that, Mr. Harpootlian. Let me see. Deadline, the Friday before. 11/7. It's going to end on a 7. All motions that you would like for me to hear that day, please have them filed.
Your Honor, may I make an inquiry?
You may.
The problem this week for, I think, us and the Attorney General is we filed a bunch of stuff, motions last Friday.
And we got
And
responses.
we had to do responses. So if perhaps you would
Set it up?
maybe move back a week
Sure.
for the motions, and then give us a week to respond, And then if you want to file some sort of SIR reply, do it at your own risk.
All right, how about October the 30th, which is a Friday? It's the day before
Yeah,
Halloween.
Halloween and Friday the 13th at this point.
Well, why not?
Why not?
Just to have your motions in, then y'all can respond the following week, and I'm putting my deadline for the 7th. Yes, response deadline will be the 7th.
So 30th first.
File your motions,
30th.
response by the 7th. So I'll have time. I mean, believe it or not, y'all, I really do sit down and read every motion that y'all file.
Would you like us to shorten them a little bit?
Always, always. The shorter the better. But I do read all of them.
I think the 6th is actually Friday, Your Honor.
It's 11/6. 11/6. All right. Anything else from the state?
Not at this time, Your Honor.
Anything else from the defense?
No, Your Honor.
All right, Mr. Griffin, you're going to let me know. Now, let me ask y'all about this. When he does let me know about the DNA, because I want to be on this. It's going to be long before November. Is it possible for us to have a quick hearing so we can decide what to do with the DNA?
Sure.
Yes, Your Honor.
Absolutely, and again, once we get that, I'm happy to
It's
work
hard
with
for
them.
me to set a date until I hear from Mr. Griffin, but maybe we could set a date, and once he calls me, and I'll email y'all a few dates, and maybe we can have a quick hearing one Friday afternoon or something.
Your Honor,
Go ahead.
you know, we need the transfer of the material from SLED Lab to Othram. You know, that's chain of custody, we're out of it, but nothing can happen until that transfer takes place.
Well, and I'm gonna talk with him about that, but thought that he represented to the court that they were gonna agree and not challenge Shane and accreditation issues and that sort of thing.
We're not.
And then secondly, we'll work on that,
Are y'all gonna turnaround's fair play, are you gonna challenge any, chain of custody on him?
Not if we agree to the procedure and my scientists are okay with it, then there would be, unless, shenanigans happen somewhere.
Okay, well, let's,
I did say shenanigans, but I
Oh
would
my
also
God.
add that
This judge is going to be so over these guys by the end. She's trying to put up with their antics. Okay.
just to be clear, it's still the same deal that I offered, that they're gonna process in quant and then stop, and then we'll find
stop,
out.
that's exactly right, you understand that, Mr. Griffin?
Absolutely, and we're coming back to the court.
I'm gonna put it all in one place,
Right.
let you process it, then you're gonna contact the court, you're stopping, you're not doing any test
Correct.
until we know, and we're gonna have a hearing on it, a quick hearing, it won't take long. You can
Othram dude's like, what have I got myself into with this one?
tell us, is there gonna be enough reserve for the state?
Correct. I just want to be clear, we're talking about the unprocessed material.
Unprocessed and the leftover is going.
It's going, but can we go ahead and test the leftover?
We're okay with that, Your Honor. They can run the leftovers. It's the unprocessed that we need the results on.
Okay, you don't need both of them to do the test?
I'll talk to the lab, I'll talk to Dr. Middleman. So I'll find out, but, we want to get this thing going.
Okay, well, I'm just telling you, before you do any test whatsoever, we're gonna have a hearing.
Okay, we won't do any testing.
Oh, we're gonna
Just
apply.
go ahead, get it quantitative.
And I guess one last thing I would ask is that by doing this procedure, they're waiving any claim under the Preservation of Evidence Act, at least as to these items.
Well, I mean, we have to, because if it's destroyed during it, I don't find that to be a willful. I read the Preservation Act, and I don't think us doing this is in anything intentionally on either side to destroy any evidence, which, you're obligated to uphold. I don't see that. So the court doesn't find that to be a problem. I mean, if it gets destroyed, y'all understand it's destroyed. Okay, all right. Thank y'all.
Thank you, Your Honor.
Court's adjourned.
Thank you, Your Honor.
I can appreciate her no-nonsense approach. We have enough nonsense in the world. We don't need to have it every day in serious matters, right? And we know these courtrooms can get spun out of control with all the terabytes, and the data, and the research, and the testing, and all the things, and get all your pretrial motions in on a timely fashion. Well, Autham's going to get their way, and they're going to have a little workup with this profile, and then I guess the judge will meet back up and decide what we're going to do with this DNA. We did need her in Delphi happy. It could have been such a difference. It could have made or broke everything, right? You want to get a fair judge and who explaining why she's thinking what she's thinking and ruling the way she's ruling, instead of just slamming the gavel down and saying, I said what I said, right? And you're like, whoa, lady, don't be so aggressive with your behavior, right? Then they got to get aggressive when they need to be. So it's interesting, though, that the defense they didn't back up their motion to dismiss the charges enough. Like, y'all, you want to put a little more meat behind that. So I don't think that's going to happen. I don't think they're going to dismiss the indictments, but at least she's willing to hear all their arguments. She reads all their motions. We need judges who read the motions, unlike Judge Fran Gull, who's like, you know what? I got your motion, and it's entirely too long. I don't want to read it. Motion denied. Like, what? Is that allowed? When did that become allowable? We don't have to read, as judges don't have to read the motion presented. How are they going to know how to rule if they never read it, right? I don't think any of them want to piss her off. They're like, oh, hell, we ain't playing in a man's world no more, are we? We're not playing in a man's world no more. This ain't Becky and her eggs and whatever was going on over there. I know Becky wasn't the egg lady, but y'all, I'm just blowing smoke. We're just being a little smoky today. And if you have a serious comment on the egg, someone may apologize for upsetting you. You're like, well, excuse me, how did you get I was upset? Oh. What? And as far as changing a venue goes, I'm going to be the last person to say don't change a venue. I'm the first person to say change a venue. But we're not doing this either. We're not going to cry foul later at the end of the trial because we didn't grant change of venue from the get-go. Now, determining if we can keep a case in the same county, depending on pretrial publicity, you're always going to be able to keep the case in the county until pretrial publicity enters the picture. Like, that's kind of common sense, right? Makes sense to take it out of that county. Makes perfect sense. But that county still has to endure that cost. And then you have to think about, now, a normal case, a different type of case, families have to travel to these new locations, right? And then put up in hotels and all the things. So this case is different because it's Alex and Buster. I don't know about the rest of the family, but there's still logistics to keep in mind too. Like they said, the parking, the availability at the courthouse, how much media is going to show up. They had to go through all that in the Koberger case to get to Ada County, knowing that Ada County knows how to handle these high-profile cases, right? We're seeing the same thing play out right now in Letcher County, Kentucky, but it's even a little more deeper there. We'll get to that tonight when I bring that show up. We got some stuff there to talk about. Yeah, I don't see they have no choice but to move it. It's a no-brainer to me. Come on, this is small town America, right? And this case has been going on for years. There was a lot of chatter always around this family in that area. There still is. It is what it is. So yeah, move it. There's way too much being said on the streets, so to speak. and then that stuff leaks out or spreads out into the rest of the nation, becomes rumors. And we seeing that right now in Idaho 4. A lot of the old rumors I was hearing, I can now see exactly where they came from by reading police reports. Oh, that's where that rumor came from. Oh, that's how that rumor got spread, right? From people in the town just talking, and that's okay. But it bleeds out, and then people start going to social media with the rumors and the this and the that's, right? And that's when it starts to spiral, and that's usually when I tune it out. If I'm really interested in a criminal case and the legal and all the things, I try to tune out the noise when it starts happening because it's easier to follow the noise, right? I don't, noise gets on my nerves if it's the wrong noise. Oh yeah, Happy. I got it's not a huge report on Letcher County, but we do got some updates in the case because it's trying to move along as well. And the judge made a couple of rulings. Can't get my hands on the actual, I might have one of the rulings. I have to check what I got because I was doing some research last night. But yeah, we're going to talk about some Letcher, just give a case update, and also Nick Houck just got his trial moved as well. So small town America is keen on moving to next counties or several counties away because I'm telling you how right here in my county, I got one county on either side of me. We're all three one and the same, right? It don't matter which, we're all three the same. We just have a different county name, but we're all the same, right? We're going to hear this shit coming through the grapevine. So that's when it has to be moved. All the pretrial publicity. But I'll tell y'all, I don't know how much that really matters. When I go back to Casey Anthony, now granted, social media, god dang, if that had been a thing back in that case, but there was 2 solid years of pretrial publicity on Nancy Grace every single night because I was there, I know, and it was wild. We saw all the jailhouse calls from Mama and Daddy and Casey, all pre-trial publicity stuff, because Florida's like, you want something here, just ask for it and you can have it. And we're not mad about it. We're gonna keep that a thing. There was so much pre-trial publicity, and they never changed Casey Anthony's venue. It stayed in the county. And guess what happened? Well, y'all know what happened. She walked right out the door, a free woman, because the jury followed the judge's instructions to the T. And I remember when he read those instructions off, I was like, oh God, if they really take what he's saying seriously, this case may not end the way America wants it to and needs it to. I knew that going into that case. And then midway through, I knew she was going to walk. And it was my stomach, I wanted to go throw up. But this is different as we got social media at play. Hey, Kresha, how are you doing this morning today, hun? This morning today. Ugh, y'all ignore me today. Yeah, you would think it would have been moved the first time, Kresha. And especially if y'all don't know, there's a lot of rumors still fluctuating around the all over the country. Was there any involvement in the killing of Stephen Smith? And that goes right back to Buster. That's always been a rumor out there. It's been looked into and investigated, not only by SLED, allegedly, but also by an attorney who was hired by Stephen's mom, Sandy. All right, I've been following that case for years. I have a Discord channel where I put all my information on Stephen in there. So I know all about that stuff as well, but no evidence has ever come. They have made no arrests in Stephen's case. None of that. So, moving the case is a no-brainer. That should be the least of our concerns. But we got some big deal with that Othram DNA. Othram's just trying to, they just, they keep bringing it up in the John Bonet case too, her daddy. Well, if we could just give it to Othram like wants everybody to know, hey, all you unsolved cases, talk your investigators into sending us that DNA. We're the best lab in the country. And you might be. You've solved a bunch of cold cases. It's the active investigations where my concern lies. That's where my concern lies. and you beefing up your legal database one swab at a time with all those old ladies from Trisha's community. What are they all going to do when they start figuring out their relatives are criminals? They're like, oh crap, that's my relative. Fuck, what did they actually? Some people are like, turn them in. Some will be like, well, what'd they do? Yeah, I know. Attorney Bland is still representing Sandy. I know. Sandy, that lady holds a special place for me. I don't know how, I don't like mothers having to bury babies and not knowing what happened to them. That's not going to ever sit well with me. Ever. Or the way babies that get lost and nobody could ever find. That doesn't sit well with me. That kind of stuff will keep me up at night, worrying. No, clerk of courts should never, ever be a worry. Right, Happy? What was she doing, ma'am? What we needed was Becky afraid Alex would walk? So she's like, I need to influence this jury and tell them to ignore that man. Are the juries that stupid? She thinks they all come from the comment section, don't she? From JLR's chat and stuff like that. She thinks they all came from there. I'd be worried about that too myself from time to time. I'm like, oh my God, when everybody's reminding me how idiotic the chats are, I'm like, I know, I see that foolish shit every day. That's your jury pool, America. Don't be mad at the process when they need to come out with a busted 100 jury questions. We have to question these jurors because, well, we see them in action on social media. They're out there accusing Patrick of murder when we know for a fact the man wasn't home. We know that for a fact. I'm not the only one saying it on the internet. We know that for a fact. Patrick was not home. Now, if he changed shoes in the car, I couldn't tell you what that man did in his own car or why he would change shoes, but some weirdos on the internet are claiming that he did. I guess their eyes are better than mine. Their sleuthing skills are far more better than mine. My critical thinking brain broke. Like y'all's brain broke. Shit. Come over here arguing with facts. Like, look at my weird video though. Don't you see it? And I'm like scratching my head going, are you all right? Y'all made me watch them weird videos in Idaho 4 and told me I was seeing Dylan and the dog pile up in this weird truck. And it was a shadow from Running Man. Running Man. We went from apartment here over to the truck. Yeah. But thanks for wasting my brain cells on here's the real killer and Dylan and Murphy piling up in this truck in this parking lot. Like, what? Yeah, that's welcome to TikTok, people. If you want your brain power and your knowledge on criminal cases in this shitty little true crime community, bust a gut getting to TikTok. Have at it. Knock the fucking doors down. All family trees built on ancestry through the 90s and onwards be property of the feds. The innocent curiosity of individuals about their history being used to solve crimes does not sit well. Nah. Look, I understand people want to know their heritage or a family they never knew they had or who their bio parents really were. I don't have to worry about any of that, right? And I've always leaned on my actual family to tell me the family heritage of what we don't know won't hurt us. I ain't trying to find them with my DNA. Like if you pop up on a census search or the marriage certificate, so be it. But I ain't trying to give my DNA up to these weird databases. You may not want to know I'm your relative, okay? I may be doing you a favor. But that's just me. I've never been into the DNA upload thingy. I was like, no, please don't buy me that shit for Christmas. I don't need America to tell me all of a sudden I have to know my heritage through my DNA. If I don't, I'm not a whole, complete individual. Something is wrong with me because I don't want to know. Maybe something's wrong with you because you got to know. I can't be a whole, healthy human until I know all of my heritage and my exact bloodline. It will change my life forever. My inner vibe will be better if I just know if I'm Indian or Italian. It will make a damn difference. Okay. If that's what you need to find yourself, you have at it. Whatever you got to do to find yourself, sweetie. My ancestors whispered to me on a daily basis, "That's enough, child," or "That's not nearly enough, child. Keep going." I'm like, "Yes, great grandma. Got you. I got you, great granny." And my granny didn't wear no weird hair bows. DNA is going to be a thing, right? And I'm not mad at them trying to use it, like even in the Koberger case, in an active investigation. But what you can't do is pretend you didn't do it. And why wouldn't you want people to see the work product? Why wouldn't you want it peer reviewed? Are there problems that we should know about? Possible problems that y'all don't want the world to know about, right? And once you get your armchair detectives to do your research and find all these random people on these trees, who's going to verify their work? Trisha, I'm dead ass asking a serious question because y'all are the ones promoting that. It's on the thing. It's on there. You can come be an armchair detective and help Othram solve cold cases. Who's going to peer review the work of the people sitting on the keyboard? Because I've seen their work in the comment section. So as strong as I know DNA evidence is, I know we're going to see problems in the future with it, right? And how you got to my client is absolutely important if you broke a constitutional right to get there. I don't care who the defendant is. I don't flip-flop on where I stand with what we should all be standing for, right? Today it's fine, tomorrow it's not. It's crazy talk. We don't do crazy talk too much occasionally. Exactly, CH, and good point, because we need to talk about that at some point during this upcoming stuff we're going to be covering. Vargas was on the defense team for Brian Koberger. And Vargas, wasn't she the one that got the little knock knock from the FBI? What are you out there saying, ma'am? What are you telling the public, ma'am, about the way we conduct our investigative genetic genealogy, ma'am? Why'd the FBI show up this lady's door? Yep, thank you, CH. That's the one, Miss Vargas. Why did the Federal Bureau of Investigations knock on her door for speaking out about something in the Idaho 4 case? Why? Why they care? She say something she shouldn't have? We'll review her reports. We'll review the documents. Because that IGG in the Koberger case is going to rear its ugly little head one day. I promise. And a lot of us had that gut feeling from the very beginning. Hold on, let me read something real quick. Lord, these people can't calm down about when criminal cases become like personal for people, like it's crazy. Hmm. She got shunned by the community, IGG community, because those doing trees didn't want the dirty secret out there, in my opinion. Because she does talk about that stuff, right? You know what I got to do, CH? And let me make a note. We need to pull up some more information circling back to that because it's been so long. I actually want to get some information pulled up about that. Because I always found it was very odd that they came knocking on her door, regardless of where I thought about Coburger, right? I can sit down my feels in a heartbeat. Like, do I even have any? So, yeah, I can set them down in a minute. Don't you be messing with these cases like that, right? Why did they go knocking on Vargas's door to silence her? And we do have some new Idaho documents that we're going to go over tonight. There's some stuff in there about Othram as well. We're going to go over later. A couple of new interviews came down in the case, not just with Turvey. And yeah, there was another new Turvey interview that I will and always will review. Whether he's full of shit or not, if he's out there gonna say it, I'm gonna listen so I can combat the fuckery. If I can combat it, I will. If he's right, he's right. If he's wrong, he's wrong. But I'm gonna listen. He was supposed to testify in court. I will listen to Cyree as well. Only way I'm going to learn if I set my feels down and listen, right? Whether he's full of shit or not. And if you're full of shit, bring it, because then that doesn't make you look good in the end, nor your case, right? So have at it. Have at it. And I'll evaluate it all day long and twice on Sunday. And maybe again that night. Yeah, because the secret about the back door. And if you go to the DOJ policy, right? I went over this policy so long ago, and it's saved here on the computer. And the FBI talked about it too in one of the press conferences. I was watching the press conferences after the plea deal to see what was asked about IGG and what their answer would actually be. Because, see, that never ever left my mind. Ever, right? I'd be an idiot if it had left my mind. I would not be a critical thinker. There's a lot to unpack with that IGG. So when Othram does their workup, guys, on this IGG, they're only allowed to go into 3 databases. This 23andMe bullshit, they don't allow it. Ancestry.com don't allow it. Law enforcement's not welcome here. Go away. And then you have to sign, you check off a lot of times, you share your DNA. A lot of places have went over that, right? So if y'all are going to upload your DNA, read all the fine print and check yes or no if you want to share with law enforcement and allow them to look at your shit when they're investigating people. Then when you can't get to the database, you go through your 3 databases and they don't find anything except for some cousins, right? That's when the FBI says, hold my beer. We'll go up to Ancestry or 23. Now, the document says otherwise. We'll take a look at it later. But we'll set up an account. Here we go. It's not like, here we have a warrant, 23andMe. We're about to enter your database to conduct an investigation. No, my name is Jane Doe, and here's my shit. Let's go. Were you just reading a tweet about Tipsy Turvey? Out of Ann J. Elise, Bicca, and Turvey. Only Turvey has had a judge threaten him with perjury. Yep. Charges inquiring him to change his testimony in CV. Only Turvey has had a judge rule he is not an expert worth a shit. Right. And Cyree, in the Colorado case, people really should evaluate that for its own merit and what that really was all about. Because I did, 2 years ago. And we looked up stuff on Turvey. We've watched past interviews with Turvey, and now here Turvey is. All of a sudden, I'm the golden boy. La, 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 la. And literally, between him and Chris Whitcomb, the lack of facts they're putting out there right now that can be backed up in court documents. Now, I know the tinfoil hat wearers, you can't believe them Idaho court documents. Go away. I'm not having a conversation with you today, right? We're not. When you come back with some facts and show me this document is wrong, then we'll have at it. But so you go back and you look at a lot of that, right? We've always been wondering about Turvey. And we knew in preliminary reports he was already saying the shady shit, like crime scene being staged, right? That was always been out there, but we never knew what Turby meant by it, where he got that conclusion. And he says right there on the custody queens, well, he called them queens of custody. On his other podcast, he's like, oh, I like talking to you about her because you're a lawyer. You're not like those queens of custody people. Oh, hey, shit, they liked you, Turvy. They were fangirls. They're queens of custody, though. Chris Whitcomb's the same way. We would rather talk to podcasts like you because, you're not fangirls. Oh, does the fangirls know you said that? Because you went and talked to them on their show. That's weird. Yeah, Turvey's got a lot to say right now, and he said something he really shouldn't have said. He got out of his lane, and he went too far into another lane that he really should have stayed out of. And tonight we'll discuss it. Turby, I know you don't watch social media, wink wink, and tiny little channels either, but you might want to tune in tonight. Wink wink. Fucker. You shouldn't have said what you said. Sorry. Shouldn't have done it. Shouldn't have done it. All right, guys, I'm going to go touch grass, admire the beauty of the tree. My son's already messaged, they lay that tree down yet? I'm like, no, but I think I need a hug. And he writes back, laugh out loud. I'm like, son, I'm being serious. I think you need to come home and give me a hug. It's never going to. But I'm going to go out there and enjoy that tree. I got a feeling they're going to come this evening when it cools off because Florida's like, we're on fire today, bitches. We're trying to murder you. And it's the whole thing out there with Florida. But I think they're going to come this evening when it cools down and cut my beautiful tree down. I will cry a little. I will weep. And then I'll come back and tune in with you guys, and y'all can make me feel better. We'll throw some shade at the shady people on the internet. Tonight might actually be a shady lady show. It could turn into that. I don't know. I'm wishy-washy. I could change in a minute when the wind blows. Yeah, the clump of hair, the clump, the 12 strands, the dozen strands. And I'm going to tell you what, all of you media personalities out there claiming you have seen the picture. I know who you are. I pay attention to what matters. I don't like the weeds are itchy. I'm sick of them. I'm paying attention to who says, I've seen the picture. I know your names, and there I've got them written down. Okay, enough of that. I see you. I'm going to watch Flawless Cleaning latest installment. What is that? I don't. Am I the host? It helps elderly people with their gardens and lives. I need a garden. CH. I need drop the link. Wait, you can't drop the link. I need. Should I write it down? Is that the name of the place? Canning peaches. Ooh, yummy. Forrest, summing it up for us there. Thank you, everyone, for being here. You're all appreciated so very much. Take care and come back later. That's Forrest's way of saying, lady, wind it down. I'm just teasing. I love my Forrest. It's my voice of reason, keeping me in line. But I am going to go make some food, enjoy my time in the backyard, have my moment with the tree until they come and take it away. And I'm going to come back later, guys. We do got some stuff to get to in the Idaho 4 case. We're going to go over some new documents that were unsealed, and we're going to go over some new, very interesting interviews. And y'all might be surprised at my take on one of them. You might be. We'll see. So y'all keep your notifications on if you don't mind. Come back in later. I'll be looking forward to y'all's company. And y'all hit the like button, get the tiny show into the algorithm, get the content out there, right? Share our community. Maybe we can draw in some more like-minded people who only occasionally wear tinfoil hats. All right, y'all. Y'all go have a good one, and I'll see you back here later on this evening. And in the meantime, be safe on them YouTube streets. A little cray-cray out there.
Thank you all for watching this here video. Please like and subscribe and follow. Much love from Little Yas to